the meeting of the Sunshine Ordinance Task Force, regular meeting, 4:03 p.m. Please call the roll.
Yes, this is the meeting of Sunshine Ordinance Task Force for August 2nd. On the call of the roll, Member Eldon.
Present.
Eldon present. Member Josh Wolf, absent. Member Copra, absent. Member Tesfa.
Present.
Tesfa present. Member Moss.
Present.
Moss present. Member Kanata.
Present.
Kanata present. Member Fisher.
Present.
Fisher present. Member Hensey.
Present.
Hensey present. Vice Chair Hyland. Hyland absent. Chair Wolf.
Present.
Wolf present. We have a quorum. There are no agenda changes that I know of at this time.
So I have a request by the task force to move item number 6, file number 17027, to the, where do you want to move it to? Okay, to the, move it to item number 3, and move all other items down one. Is there a motion for that change?
I'd like to make that motion.
I'll second.
Moved by Member Tesfaye, second by Member Fisher. Public comment?
Good afternoon, task force members. William Clark. I'm opposed to that motion. I just am here for reconsideration, and I think I'm number 4 on this, and so I'd like this by roll, please.
Any other public comment? All right, so the reason why we're moving this is because one of our members has to leave soon, and she is chair of the committee that heard this complaint, and we would like for her to be present for it, and to also provide the summary of the presentation of the case. So that's why we're moving that item. Any further discussion? Seeing none, can we take that by acclamation? Seeing no objection, and recognizing Vice Chair Hyland is now present.
The motion passes with Member Josh Wolf and Member Copra being absent.
Okay. Okay, let's call the next slide.
Next on the agenda is item number 2, approval of minutes from the Sunshine Ordinance Task Force July 5th, 2017 meeting.
Is there a motion? Motion to approve the minutes?
I'll move to approve the minutes.
Second.
Moved by Member Hensey, second by Member Kanata. Any changes, discussion, edits? Nothing, public comment on the minutes? Seeing no public comment, can we take that by acclamation? Seeing no objection,
That motion passes with Member Josh Wolf and Member Copra being absent.
please call next item.
Next on the agenda is item number 6, file number 17027, complaint filed by Anonymous against Ann Brash, Christine Silva, John Rayam, and the Planning Department for allegedly violating Administrative Code, Section 67.21 and 67.25 by failing to respond to an immediate disclosure request in a timely and or complete manner. This matter was reviewed by the Complaint Committee on May 23, 2017, which determined that they had jurisdiction, and they did send it forward with a recommendation that there is no violation.
Member Tesfaye, you want to start the ball rolling here?
Sure. So when we had the hearing for this case, the petitioner wasn't present. We did have a member of the public speak kind of towards the issues of the petitioner and providing some samples of past actions that were similar that the planning department had done with others, including herself. The planning department was present, and they stated their position, and they showed, why they felt that they were in compliance with the requirements of the ordinance. And that included a timeline of their actions and summarizing which documents they had provided to the petitioner. But the petitioner wasn't there for themselves. The petitioner was anonymous. I guess the reason that we were thinking that there might not be a violation here, and usually we don't do that, but in this case, it appeared that the planning department had provided information. It's just that the petitioner was kind of questioning the validity of their responses. You know, they provided the document, and then the petitioner was saying, well, there's like mistakes on the document, or the document isn't correct, or some of the conclusions within the document are incorrect, and we kind of felt that that was different from the actual act of producing the documents. And so there weren't really any additional public records that needed to be produced. The records that were requested were produced, but it was just that it was the contents of them that the petitioner had a problem with. But that's what we have, and if the petitioner is here today, then maybe we can get additional information on their position.
Okay, so let's hear from the parties.
Just note, I just received an email from the petitioner. He is ill today, unable to attend. He did authorize Elaine Sang to represent him at today's meeting, but I don't see her in the room at this time.
Yeah, I think, that Ms. Sang is that person that was there last time that spoke.
How do you want to proceed?
My pleasure would be to reschedule this. And I don't know if Ms. Sang just happened to be there that day. I think she's been before us before, and I think she had her own item, but she didn't appear to be involved in the case. So I don't think depending on her to be present to speak on behalf of the petitioner is fair, yeah, on her or the respondent. So
Okay. So do you want to?
That's how I feel, but I mean, others might feel differently when they looked at the packet, if they feel
Well,
that they can move
I'll
forward.
go with whatever motion is on the floor. If there's no motion to continue, then we'll move ahead with the case.
I'll make the motion to continue this item.
Two. Second.
Moved by Member Hinsey, second by Member Fisher. Is there any public comment on continuing this item? Members, or is there any discussion from you on this? No concerns? Okay, can we take that by acclamation? It's just procedural at this point. Okay.
I think the other party wanted to comment.
I think the respondent was raising her hand.
Okay.
I can't
Well,
tell.
certainly,
Oh, there she is.
come on. That's what public comment is for on procedures. So that's fine.
Hi, Christine Silva, planning staff.
Yep.
This is the third time that we've gone scheduled for hearing, and then they're not present, and then we continue it again. And I feel like in this scenario, we did provide the responsive records in the timely manner, and we're not.
Okay,
against
so
the government code.
let me just ask, 17027, that's been rescheduled 3 times before the task force?
Oh, he wasn't present at the committee meeting, but it hasn't been before the full task force.
So this
And then-
item has not been before the task force before?
It was scheduled for July 5th, and then it was continued to today. So we've had a couple of hearings where.
It was scheduled at the last full task force hearing date. He did request a continuance to a future date, and it was rescheduled for today.
Oh, so it didn't actually appear on the agenda, though. It was.
It was continued before the 5-day.
Oh, okay. Okay. With that,
Through the chair, but he's
Yep.
he's already asked for one continuance. This
Right.
is the second,
this is when it got rescheduled.
Okay.
and he hasn't showed up.
And he hasn't showed up. So what is your pleasure? Do you want to hear the case, or do you want to continue it? Yes, absolutely.
Yeah, through the
Sorry.
chair. I'm not
I'd like to table it.
tabling it. Through the chair, tabling it means
That you basically close the
he's done
case.
and he has to reopen.
Yes.
And as I said earlier, I feel like he's received the documents. He has an issue with the validity of what is there, of some conclusions that were made, but that's a
No.
little bit different from
The receipt.
receiving more. There's no more documents to receive from what I've.
I'll
mean-
go with that then.
So if you want to hear the case and there's these facts that are being presented and it seems like we can get through it fairly quickly, I would do that and then have a definitive determination, and then it's done and over with.
Through the chair.
Yeah.
If so, there's a motion on the table. We should probably either withdraw the motion or vote on it as procedural, right?
Right.
Secondly,
This is right. We're discussing whether to continue it or not. Right.
right, and that was based on facts that are now not in, we're not in possession earlier. Now we know the full picture. So, my thought is the original. I'm happy with the original subcommittee's recommendation that there is no violation, and to conclude this matter.
I will not allow us to take a recommendation without hearing the merits of the case first.
Okay.
So let me get my head around this. We could either withdraw the motion, or we could vote against the motion, it's the same thing, and then motion to table and move on.
Well, usually the person who moves and seconds it usually is in support of the motion.
That would
so
be odd,
it'd be a
wouldn't
little
it?
bit
Yes.
odd.
Yes,
So
it would.
it would be preferable that the maker and the second rescind the motion.
Okay,
And
it's on you. It's on the maker then.
I would be comfortable rescinding if that's the way we want to go.
Does the second agree?
Yeah, I'll agree with that.
Okay, so now we're back to the case. So we will hear the case through and make a definitive determination.
Well, what happened to tabling?
That can come after.
Well, if you wanted to table it, you could just table it right now and make it go away. I don't think that is appropriate. I think that you have the other party here. If both parties didn't show up, I would say, yeah, let's table it, or just close it. But since one of the parties here and she wants to make a case of it, I think we should hear it out. Okay, so let's proceed. So first,
Do that quickly, then.
let me have you step away for a second. Is Anonymous here? Anonymous is not here. Are any persons or witnesses provide any facts or evidence on behalf of the complainant, the petitioner? Seeing none, respondent, you have 5 minutes. Oh, yeah, there was jurisdiction on this already? Yeah.
Thank you.
Good afternoon, Chair and members of the Task Force, Christine Silva, Planning staff. On Tuesday, February 21st, the Planning Department received an immediate disclosure request via email requesting information related to a CEQA categorical exemption checklist for the project at 2650 Hyde Street, which is Exhibit A in your packet. Upon receipt, staff reviewed the request and on the following day, Wednesday, invoked an extension due to the need to compile electronic information. On Thursday, March 2nd, staff completed review of the records and produced those records via email with attachments, Exhibit C of your packet. As of Thursday, March 2nd, staff considered this request complete. On Monday, March 6th, staff received an additional email from the requester, unsatisfied with the records provided, questioning the veracity of our response and of staff's analysis of the project itself. After internally reviewing the email, staff provided an additional document, a plan set, which was responsive to the requester's additional questions, and also which was previously provided as a responsive record to a December 2016 request by the same requester. The complainant alleges that we are in violation of Admin Code Section 67.21 and 67.25. That assertion is incorrect. The requester was notified of the extension before the close of business the next business day, and the responsive records were produced to the requester within the 10-day extension. Also of note, during this time period, staff did reach out to the requester offering to set up a meeting to address his lists of questions, but he refused. I have a copy of that email exchange should you want to review it. Happy to answer any questions. Thank you.
Are there any persons or witnesses on behalf of the respondent providing any additional facts or evidence? Seeing none, members? Member Canada?
I kind of agree with the conclusions that it seems like the argument is with the conclusions in the data that was submitted, not that he didn't get the data he asked for. So,
My only question would be, was the data they received, was it responsive? We don't have them here to answer that question, but that would be my only other question, and I don't know that it's necessarily without him answering what that exactly would be. It would be a little one-sided to ask the respondent for a response on that. Member Eldon. In the microphone, please.
He didn't actually say it wasn't responsive. It sounds like in the complaint, though, right? That wasn't the issue he had with it.
No, from the presentation, it sounds like he had concerns about the content
Right.
and the actual analysis within it. So that's kind of all the information we have from the complaint committee. Okay. All right. Rebuttals. You ready, Vice Chair Highlands? Something you want to say? No. Okay. Let's move to rebuttals. Respondent first. Any rebuttals? No rebuttals. Declines. Anonymous complainant. Any rebuttals? Not here. Is there a motion?
Motion to adopt the complaint committee's recommendation of no violation.
Second.
So moved by Vice Chair Highland, second by Member Hinsey to find no violation. Is there public comment? Seeing no public comment, members, any last words on this item? Please call the roll.
On the call of the roll, Member Eldon.
Aye.
Eldon, aye. Josh Wolf, absent. Copra, absent. Member Tesfa.
Aye.
Tesfa, aye. Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Member Fisher. Aye. Fisher, aye. Member Hinsey.
Aye.
Hinsey, aye. Vice Chair Highland.
Aye.
Highland, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Let's call the next item.
Next on the agenda, item number 3, file number 17060, complaint filed by Michael Gray against the police department for allegedly violating Administrative Code Section 67.21 by failing to respond to a request for public records in a timely and/or complete manner. On June 20th, 2017, the Education Outreach and Training Committee determined that the task force has jurisdiction and referred the matter to the task force with a recommendation to find a violation of the Sunshine Ordinance.
Can someone from EOT make a presentation on this? Okay.
In the notes that Victor sent, there's a summary as well.
Best as I could. Wait, when was this from? Last year. Okay.
No, I got it. So basically,
Can you pull the microphone,
In the
please?
microphone, please.
basically, Mr. Gray was trying to find out if there were responsive records that weren't being disclosed to him as part of a group he had tried to join and been rejected from, and the police had said there weren't any, and we had asked the police to make sure that was the case and to explain further.
Were those documents provided before the meeting or during the
Not
complaint?
before our meeting. I don't know if
Okay.
they've been provided since. I don't think he is here today.
Are both parties here? Is Mr. Gray here?
He's not. I don't think he's here.
SFPD's here. Shall we move this forward or shall we wait? Victor, did you get any
I
word
did
from
not
Mr. Gray?
receive any
Communication from Mr. Gray?
communication recently from Mr. Gray.
Okay.
Through the chair.
I'm sorry, through the chair. What I vaguely recall is this was another back and forth of, I want the records, but then the records were personnel records and they couldn't be released. And I recall that's where we left it.
And in addition, I believe there is an agreement signed when you apply for that specific
Yeah, the
job
agreement.
that you agree to waive your rights to certain documentation.
Well, it's kind of threading the needle because I vaguely recall, and maybe the
All right,
Captain Lieutenant could
if we're-
tell me it's
If we're
something.
going to get into the details, then
Okay.
let's hear the case.
Well, it was just the background
And there was
information
one
can be
question that the
released.
committee did have. The committee requested that the police department provide information as to whether or not the police department had responsive records that could not be disclosed, or if they just provided a general statement that that type of record would not be provided.
And through the chair,
Yeah.
what are the additional documents that have been provided? What is that referring to?
I believe this is testimony that the police department may
Okay.
be better equipped to provide.
So let's move forward with the case without the petitioner, and we'll see if we have enough to go on. If we'll decide how to move forward. So let's hear from the petitioner first. Petitioner is not here. Are there any persons or witnesses on behalf of the petitioner provide any additional facts or evidence? Seeing none, respondent. Oh, and jurisdiction on this was that?
We did make the determination.
Okay, great. Thank you.
Lieutenant, right?
Lieutenant, yeah.
Yeah, Lieutenant Wallen.
Lieutenant Catherine Walland, on behalf of SFPD Legal Division. So I believe the original complaint was that we did not answer in a timely fashion and that we did not provide the documents. So our response to that was that the documents or the response was provided within 10 days following the receipt of his request. The envelope was time-stamped when it was received, and a response was on May 23rd, and a response was provided on June 1st and June 2nd. Mr. Gray's original request his request was part 1. Please provide any and all correspondence, notes, emails, or other documents related to my application for job number and title with the Office of Citizen Complaints. The San Francisco Police Department does not have documents related to his application as he applied for a job with DPA OCC. It's a separate agency of the City and County of San Francisco. So he was directed to contact DPA and DHR, who do participate in the application process. Job announcements, job offers, that wasn't something that our department had a part of. He requested correspondence, notes, and emails and other documents related to the job offer. Once again, the job offer was not made by the San Francisco Police Department, so we directed him to the DPA, who is the agency he was applying for a job with. Questions 3 and 4 were consolidated in our response. He requested provide any and all correspondence, notes, and emails related to the background investigation, and provide any and all correspondence related to the failed background investigation for job number with the OCC DPA. So we responded that we understand that his request is asking for information that's contained in a background investigation. We declined to release the records on the basis of Privacy 6254C and Article I, Section 1 of the California Constitution and the United States Constitution, because disclosure of this information would constitute an unwarranted invasion of privacy. Disclosure under the Public Records Act to one person would render those documents public to everyone else. In addition to the right of privacy, the requester had signed an authorization and release form, which acknowledged that the information contained in the background investigation is privileged and would not be subject to disclosure. Specifically, the person signed a document stating, by the consenting to the above with my signature below, it is my intention, and I do hereby waive any and all rights granted to me by federal or state law. I understand that I will not receive, and I am not entitled to know the contents of confidential reports received, and I further understand that these reports are privileged. So we declined to release those documents.
That it?
That's it.
Okay, thank you. Are there any persons or witnesses providing any facts or evidence on behalf of the respondent?
Ann Turbo, I speak from 2 points.
Is this in support?
In support.
Okay.
After reviewing the file, first off, the complaint is solely for the timeliness. That's the way it's written, and I know what a stickler you are for headings. That's kind of important to you guys. So the issue of the content was not included in the heading. Secondly, this request was sent by mail and not by certified mail. So the date stamp on it of when it was mailed was a day after it was sent. Still, it was received and responded to within the 10-day window. For some reason, the police department got this guy's email wrong, and when they realized they made the mistake, the very next day, they sent it out under the correct email, which was still within that 10-day window. So 6725 for timeliness does not apply because it was responded to within the 10-day window. As far as the content of it, it seemed he consented to this type of disclosure, and the documents were not in the possession of the police department. It was another department, and he was directed to go seek that information in the other department. So that's my review of the file, but also on a personal basis, I made an IDR to the police department, and I find the way they did things was wonderful. You could track it online, you got the number, you could track the progress, you could see what was going on. So by his not presence here today, and the fact that there's no real additional information from the guy, he certainly had every opportunity available to him, and in my view, no violation occurred.
Thank you. Are there any other persons or witnesses provide any facts or evidence on behalf of the petitioner? I mean, the respondent. My mistake. Okay, seeing none. Okay, members. Questions, answers, discussion? Lieutenant Walland, I just have one question. The document that he signed, was he waiving his right to privacy on that? And you declined to release the information anyway, or did I get it backwards? Was he retaining his right of privacy?
He was waiving his right to any documents contained within, related to the background investigation.
I'm still not following. What does that mean? Does that mean that he wants the documents or he doesn't want the documents? Or he wants the documents without confidential information in it? Or
He made a request for his background packet.
okay.
But upon initiation of a background, he had signed, before engaging in the process for the documents he's now requesting, he already agreed that he had no right to those documents.
Oh, okay. All right. Thank you. Oh, one more question. When did you receive the IDR?
This was not an IDR.
Oh, it was not an IDR.
No.
Okay.
She was talking about an experience that she had.
Oh, okay.
With
my mistake.
an IDR.
Okay, great. Thank you. Okay, members? Is there a motion?
I'll make a motion for no violation.
Moved by Member Eldon.
I'll second that.
Second by Member Fisher. Public comment on the motion for no violation. Seeing none, please call roll.
On a motion to find that there was no violation, Josh Wolf absent, Copra absent, Member Tesfa.
Aye.
Tesfa, aye. Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Member Fisher. Fisher, aye. Member Hinsey.
Aye.
Hinsey, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Member Eldon. Eldon, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Let's call the next item.
Next on the agenda is item number 4, request for reconsideration of complaint. File number 17009, complaint filed by William Clark against Tom DeCagney and the Arts Commission. On June 8, 2017, Mr. Clark, the petitioner, requested reconsideration of the order of termination, finding that a violation of Sunshine Ordinance Section 67.4A occurred for failure to make a passive meeting accessible to individuals upon inquiry. Mr. Clark believes that due to new evidence, the community working group should be considered a policy body and not a passive meeting body. If the task force determines that the complaint should be reconsidered, a hearing on the merits of the new information will be scheduled for a future date.
Victor, can you remind us what the decision of the task force was?
The task force found that, determined that the working group is considered to be a passive meeting body, and found that they failed to make the passive meeting accessible to individuals upon inquiry.
And did not?
They did not.
Okay. Yes.
If this is a request for reconsideration, in order to determine whether a reconsideration is proper, you first want to find out if there's new evidence that wasn't available at the initial time of the hearing. Just a reminder.
Okay. Thank you. Okay. Go ahead.
And that was in the packet. There was new evidence that's in the packet that they gave us.
Yes, it is in today's packet.
Yeah.
Okay, so let's hear from the petitioner. Petitioner?
Victor.
Hello, Task Force members. William J. Clark. I'll try to make this easy. I submitted 2 documents to you which were not available to me or at the last hearing when you met on this matter. One of the documents contains the meetings and the details of what took place at those meetings, of 5 different meetings of the community working group. And the other document is a document that was given to me at the last Art Commission meeting, a proposed work plan to modernize the street arts program, in which that the second document contains relevant cross-references to what the community working group had accomplished and what had been approved, what their recommendations were regarding the work plan, and what the Art Commission's outcome was, and how they decided what they were going to do. The first document, which I just wanted to mention to you, that the blackened out lines in that document were meant to be highlighted areas, not crossed off areas. So I know it came across that way. But I would like to have an opportunity for you to look at these minutes of these established minutes which were presented, which were created by the working group. And I would like you to have me to have an opportunity that I could go over them and show you that this was a policy body, that it was created by the Arts Commission, and it advised the Art Commission and made recommendations to the Arts Commission, and therefore it should be by the Sunshine Ordinance, which you went over in detail last time, it should be defined as a policy body and not a passive meeting body, because the working group was created by the Arts Commission when they created the working plan. And just to point out, in the one section here on the working plan, it says 1.3 to establish an ad hoc community working group, and underneath that they made a statement that said, unfortunately, Mr. William Clark filed a sunshine violation regarding the procedural format of this group, which was upheld by the Sunshine Task Force on June 7th. You upheld you ruled it to be a passive meeting body, and I believe that these documents clearly show that the working group was conducting meetings where they discussed and detailed all sorts of issues that were brought up in the working plan, and that they made recommendations through the staff to the Full Arts Commission, and therefore I believe that you should reconsider this matter and at least give me an opportunity to address this new evidence at another hearing. If you decide at that point not to change your mind, then I would accept that, but I would like that opportunity to present this to you. Thank you.
Okay, let's hear from the respondent.
Hello, good evening. My name is Ann Trickey. I'm the market manager with the Street Artist Program. I'm here in lieu of Kate Patterson, who I'm sure you know, who usually appears before us. I actually prepared all of the information in regards to the working group, and am the only staff member to appear before the committee here in the task force that ever participated in the working group. So I can speak directly to it. One, we're no longer holding the working group, so I'm not sure if this point is even valid since we are no longer holding the meeting. Two, I just want, and maybe I just need clarification from you. It's my understanding that discussing policy doesn't mean making policy. If I get together with my staff members and I discuss a policy item and maybe something that we'd like to see changed, I still have to go through the policy body that actually makes the policy in order to do so. So having a group that discusses policy doesn't make them a policy body. And I still don't know how that affects this task force. If you have any questions, I'm happy to answer.
Okay, thank you. Okay, members? So let me provide you with the scope. The purpose of this is to determine whether there is enough evidence brought by the petitioner for reconsideration to reopen the case and bring it back to the point just before the vote. That was the area of discussion and question and answer. That's purely what we're deciding here is, does the new evidence reach a bar to provide us with enough new evidence that this that the determination we made may have been incorrect. Member Josh Wolf, and recognize his presence.
This is I'll make this as brief as possible, but and it's a point of order. But I think that we would need to really go back to not the vote itself, but before the motion was made.
That's right.
Okay.
No, it's actually just before the vote, and then whether to we would then find that vote either we would continue to support it or not, and based upon the new evidence. And if we decide not, then a new motion will be made on the floor. The idea is not to rehash the entire case all over again unless the information was that significant.
So we did find a violation, right?
Yes.
So,
but he's stating that we misinterpreted the Sunshine Ordinance in that this group was a passive meeting body. That's what we found. He's stating that it should have been found to be a policy body.
Right. And so my concern is that basically, even if we were to find the motion for reconsideration right now and then go to the vote, with this new information, I think we may come to the conclusion that it is a policy body, but I believe the violation remains the same. And so Dave disagrees, so I will just end there.
Member Moss?
Yeah, so if I recall correctly this was a sort of contentious vote in the end, and that we ended up seeing that there were two different series of violations that would have to happen. If it was a passive meeting body, it would be one series of violations under one part of the Sunshine Ordinance, and if it was a policy body, it would be a different section. I'm inclined to reconsider this. I can wait to make the motion in a bit if we want to discuss more, or
Sure.
I can make it now if you guys would prefer.
Through the chair.
Let's hear from Vice Chair Highland.
I'd actually
first.
like to hear the basis of his reconsideration, just to kind of hear him out.
Well, if you're going to, if you find that you want to allow the reconsideration, I would suggest you make the motion so there could be discussion about that.
All right, then I'll move to reconsider this matter.
I'll second.
So moved by Member Mott, second by Member Eldon, who I saw first. Okay, go ahead. Make your point.
So I think that there was a lot of discussion and contention about this at the time. I think that if the information to me does look like it's new information, and that if we discussed it again, we may come to a different conclusion. We may come to the same conclusion, but I do think it's worth discussing, because the decision we made was not just in finding a violation, but it was to an extent determining what this body is and is not, and it's something that could set precedent for things we do later on down the road. So I'm inclined to both reconsider and for us to just make sure we're very careful on this.
Let me ask you a question. Do you find that the new information that was presented is compelling enough to cause a reconsideration?
I find it very interesting. It's hard for me to answer because I voted no on the previous
That's
motion.
of no consequence.
So-
Now you're being presented with new evidence. Do you feel this new evidence is so compelling that it would change your vote?
No, because I voted no on it before. So, it wouldn't change me to voting yes, because that's not what this evidence is pointing to.
Then I don't see the value in the reconsideration because the purpose of the reconsideration, the bar is, does the new evidence...
Can I put it in a different way?
Okay.
I believe that the evidence that has been presented is significant enough that it may change the votes of other members of the task force. Right, and it would change my vote if a different motion was made. If the first vote fails, it would change my vote on a different motion.
Okay, fair enough.
Quick question. Could I just verify the respondent? This document that we received, this is indeed something that you put out, because there's no real evidence that this could be from anything.
So I believe, and I'm sorry I didn't pull it up on my phone, but I believe what Mr. Clark gave to you was actually a draft document from which I read at the meeting in question, where I gave a report back to my committee on what the working group had completed. Did not make it into the final minutes of the committee, so I can send you that if you'd like, but what he's reading is not the actual final full minutes and information that made it into our, accurate documents.
I guess what I'm asking is, have you seen what's in our packet?
I created that original draft, so yes, I wrote it.
So it starts with notes, semicolon, SAP Community Working Group meeting.
Yeah, correct.
And it has a date, 5/9/2016.
Yes.
Okay, so
I prepared all of those documents,
okay.
so yes.
And then what's interesting to me is you said this is a draft.
It was a draft that I was reading off of notes, so I had to, I'm the market manager of the street artist program. So my goal, I was asked to report back on accomplishments for the work plan, and I had written myself some notes to read off of, and then from the minutes, the audio minutes, I created the final formal minutes, which is not what you have, I believe.
Okay, so you are saying that, so this is kind of a cheat sheet for yourself,
correct.
basically. Okay. But then meeting minutes were?
Correct. As with all of our public meetings, we have to create minutes. I can send them to you if you'd like.
Okay, but this meeting was not agendized, right? You didn't give any notice of this particular meeting?
No, no. You're looking at cheat sheet notes for myself for a standard committee meeting of the Street Artist Committee, which is a policy body. So yes, we notify per usual all of the regulations. Our violation was not found with the committee meeting. It was with the working group, the ad hoc community working group.
Okay, that's what I'm trying to establish here. So this is in no way a document that was...
It was not. The working group no longer is meeting.
Well, that doesn't matter. We're still
Okay.
looking at when it did occur in time. So when that working group did meet, there was no notices, no agendas, no...
It's not a... Yeah, it was just a ad hoc meeting. It only had one staff member, and everyone else was street artists, members of the
Gotcha. And did you
program.
Did you distribute this? Did you make this publicly available? The
The final minutes I did make publicly available.
The final minutes of?
The Street Artist Program Committee, where I read off of that document.
Okay, but the working group doesn't have any minutes.
The working group has notes that were made available to the Misters Clark and everyone else who requested them, and were also given you in your previous packet that you reviewed.
I see. Okay.
Member testify.
I have more, less of a question and more of a comment for everyone. Chair Wolf asked, does this new information, these new facts, is it something that we find compelling to hear again? And I just want to say that I feel like I need more information on that. I have read through them. And to your comment about the blacked out area, we got a color copy so we could tell it was highlighted, not blacked out. But I just don't know, is the highlighted information something that's critical that tells us that this working group was actually a policy body, not just a passive body? I'm not sure what this document is trying to tell me. I see it as, some notes, but I don't see how it is supposed to support an argument that this is a committee, a policy body versus a passive meeting body. So.
Okay. Great. Anybody else? Member Canada?
Yeah, I agree with that viewpoint. I think in order to reconsider, we would have to determine individually, I guess, whether the new information changes the definition of the body from passive to policy making.
Okay. Anybody else? Okay, Ms. Trickey, I have a question for you. Do these draft notes represent what happened at the group's meeting?
Yeah, it is a summary of what happened at the meetings for a report back to the committee members, who are commissioners appointed by the mayor.
Okay, great. Mr. Clark? So I wanted to give you a little bit of latitude and opportunity to, because for me, I'm reading it off of the electronic PDF. I can't, it's very hard for me to read what it says. Victor, if you're going to give me a color copy, you got to give everybody a color copy. Okay.
That's where I got mine from.
I don't. All right, fine, fair enough. You can give me a color copy then. I did not see it. I must have missed it.
Just to let you know, I have a blacked out copy myself, so it's difficult for me to read it also. But my original was just in yellow.
Okay, I'll look for it later, but I don't. Oh, here, in color. Got it. Okay. Okay, so I just want you to point out for us, make your case as to why you think this evidence that you now have brought, this new information, now is so compelling that we should, that it would change the outcome of our determination.
Thank you. First, I want to point out that it seems to me that the Arts Commission is under the misimpression.
I would really appreciate if you can just point.
Well, I am, but it's important that I make this reference because it's relevant to the question you just asked me.
Okay.
The Arts Commission seems to think that a policy body has to be a body that actually makes the decision. And a policy body by the Sunshine Ordinance doesn't have to make the final decision. It's just an advisory group that's created to discuss issues and then make recommendations to the original policy body. That's why I wanted to make that clear, that they keep claiming this isn't that for that reason. And there's several things in here that points out what I wanted to show was that there were I gave you two documents because she confused you. One document is the meeting notes from which the president is referring to, and the other one is something she read in front of the street artist program. The meeting notes themselves contain the discussion agendas of several things that occurred at each meeting that were policies that were recommended to the full Arts Commission. At the first meeting, under Section C, on the second page, on Section C, it says streamlining the payment process. And that's a whole new policy that was implemented by the Art Commission as a result of these recommendations that came out of this particular committee meeting. All artists have to provide email addresses upon applications and renewal. New policy that came through. At the second meeting, I highlighted numerous things because I felt like they were policies that were discussed along with their recommendations to the staff and to the Full Arts Commission, including, we need to determine the criteria for effective screening committee members.
I understand that, but
okay.
under 67.3, which describes policy body.
Right.
Okay? Now, I'll just read it. It's very short.
Right.
It's either, a policy body shall mean 1, Board of Supervisors, 2, any other board or commission enumerated in the charter, 3, any board, commission, committee, or other body created by ordinance or resolution of the Board of Supervisors, 4, any advisory board, commission, or body created by initiative of a policy body, 5, any standing committee of a policy body, irrespective of its composition, 6, a policy body shall not include a committee which consists of solely of employees of the City and County of San Francisco, unless such a committee was established by the charter or by ordinance or by resolution of the Board of Supervisors, and 7, any advisory board, commission, committee, or council created by federal, state, or local grant, whose members are appointed by city officials, employees, or agents. Which one of those?
Number 4.
So can you point to the initiative of the policy body that created the body?
The Art Commission created the work plan.
Do you have evidence of that?
Yeah, I gave it to you at the last hearing, but it's also in this new document I presented to you entitled Proposed Work Plan to Modernize the Street Artist Licensing Program. Under heading number 1.3 says Establish Ad Hoc Community Working Group. The working group was established and met 5 times. Now, it was established by the Full Arts Commission. The working group only came into being after the full work plan was approved by the Arts Commission, which included creating the community working group. And that's why I'm saying, and I thought last time around we had a good discussion about that, whether or not who did initiate, whether this was initiated by staff or by the Full Arts Commission. And I gave you the date which the Full Arts Commission passed that resolution approving the work plan, and pointed out to you that the working group would never come into being, not even by staff, unless the Full Arts Commission had approved its creation.
Thank you. Member Joshua.
I'm not sure whether I heard this correctly, but I think the testimony from the representative from the Arts Commission said that the working group was created by the Arts Commission. So, doesn't...
Okay, so we have a motion on the floor. Do we want more?
Through the chair?
Yeah, Member Moss.
So one other thing that I'd like to point out that I found troubling going through this did not come from the petitioners, but had come from Kate Patterson's response. Mm-hmm. In her response for this committee, she made these claims that the Art Commission had always believed this to be a passive meeting body. And I clearly remember her during the meeting saying, we don't know what it is. We'll let you decide, and we'll follow whatever you decide. And so I just want to add that it's very weird that they're sort of changing the record when, as Member Wolf pointed out, that they had said that this was created by the Arts Commission and they were willing to take our advice on it. So I don't remember them making the claim that they're making now in this letter.
Okay. Member Kanata and Vice Chair.
I remember the discussion last time in trying to decide what type of body it was. One of the differentiations was it created by the Arts Commission or by a member of the Arts Commission? Because in that same paragraph, a passive meeting body shall mean advisory committees created by the initiative of a member of a policy body. So that was one of the main discussions we had.
Okay, Vice Chair Howland?
Yeah, just looking at that, in the charter, member of policy body, the mayor or department head. And we grappled with this last time around. The language is not precise enough. This is something we should probably if and when we revise this charter or, have edits, this should be one of the things, because, how is that different if the department head says create this this working group, or created by the policy body? And in many cases, the buck stops at the department head for a lot of the things that we rule on. So this is not clear language. Regardless, there was some, I think, gray lines the last time around. I'm convinced by the plaintiff's arguments this time around, and the fact that some of these notes have become actions adopted by the Arts Commission persuades me that we should be considering this, and should have considered this, as a fully fledged policy body the first go round.
Okay.
So I would be voting in favor of that motion.
Okay. Any other members? Any other comments? Let's get Member Eldon, then we'll go to public comment.
That's basically where I'm at too. It seemed like it was a pretty gray area before, and the fact that this is they're talking about recommendations that are becoming policy is like the smoking gun for figuring this out.
Okay. Public comment.
I'm troubled by two things. Firstly, the response of the Arts Commission, page 92 and 93. They say that on page 93 that the Arts Commission did provide agendas and meeting information for those who requested them. I made a specific request for the agendas and meeting information, and I was told they didn't have any. And they say that this information was not withheld. That's not true. So I was present in all of the meetings and discussions about this, and the idea that there was a fight in the meeting, apparently. One person didn't want to be audio recorded. The other person, something happened. They were in this room. They were talking about it. So, there's a lot of things going on that need to be considered. I don't think that it's specifically this new evidence of some draft things that were not available to me. I was told they didn't have any documents. So it's very wishy-washy in my opinion. I think that people should have been able to attend that meeting. It should have been open. Maybe they could not have been allowed to participate, but there should have been a record of it, and it would have benefited all the street artists out there. Instead, it created an enormous amount of confusion. People thought that if they went into that building, they would be arrested. They wanted to go in large numbers, in an angry manner, and that's what happens when there's not full disclosure or transparency. And I don't even think to this point there is transparency, because what you have are some draft notes as records of, I think these meetings went on for 1.5 years, and there should have been a more clear record, and the information should have been available.
Robert Clark. A couple of points. First of all, in this proposed work plan that Ann Trickey read in front of the Street Arts Committee, this is word for word what she read in front of the committee. She may have adjusted it slightly. I know my brother filed a complaint with the Art Commission about the comment about, unfortunately, Bill winning his case here. I felt that was insulting on his right to petition the government for a redress of his grievances. But I did want to mention that in this new evidence, it clearly states in one section, 2.3, where it says revived grace period, it says, as recommended by the working group, there is now a fee for rescheduling a screening with less than 48 hours notice. And that was the big argument that was the Art Commission was trying to say. They're saying the working group isn't recommending things. They're just telling us their opinion, and they're not recommending stuff. But yet, right here in this new evidence, she states clearly that, as recommended by the working group, that a new fee is now in effect. So these are the kind of things in these papers that we would like the task force to look over in the next month. At the last hearing, the chairman himself voted that this was a policy body and not a passive meeting body. And, I wanted to remind the chair that occurred at that time, and that there didn't seem to be a question about whether or not this was initiated by the Arts Commission. The question was pretty well clarified that yes, it was, and that the problem that we were having is that this concept of, are they an advisory body? Are they recommending things? And if that wasn't the case, then maybe they're a passive body. But I do think that there are several things in here that were written by Ms. Trickey and in the other evidence that clearly show that the working group was working as an advisory group, was recommending certain changes in policy should take place, and then the Art Commission acted on those recommendations without having any hearings in front of the Street Arts Committee. Like this fee exchange process, there was no public hearing in front of the Street Arts Committee where we could even discuss whether or not we wanted that to happen or not. This was put into effect immediately after it came out of the working group, and the staff sat down and decided that they were going to go ahead and do it without having any meetings. And this is important because we feel that if the proper judgment is made and that this is considered a public policy body, then the violations do change. And some of those violations are very serious violations, like the violation of the Brown Act. So I recommend that you vote in favor.
Thank you.
Hello. I just want to be sure I'm doing this correctly. I'm still learning this. Start. Okay. Hi, my name is Jason Grant Garza, and I have the distinct displeasure of being before the Ministry of Sunshine once again. The reason I call it the Ministry of Sunshine is because this group here is nothing more than a shill group, risk management group for the city and county of San Francisco, because even with the whole truth, it's still rinse, lather, and repeats. In this particular case, for example, when the people were up speaking, the complainants were up speaking, it seems as if this body was more hostile than adversarial than being an advocate for them. Mr. Clark, Mr. Hart, myself, for example, have brought numerous complaints against the same agency repeatedly over years. But since this task force is ineffective, can't set precedents, can't do anything, we are the heroes because we keep coming back when you guys keep screwing up. There should be deference made to us, not the other side. It completely and totally, does not do what you say because they keep showing up here again. Obviously, they never learn. But you sure have learned to pick on the victims. Maybe this is why nobody ever comes and complains. Because you guys aren't helping us. You're helping the city. How many orders of determination do you have against the Department of Public Health? Or Angela Cavillo for Mr. Hart's? Or the Arts Commission for these people? How many over the last year? Shall I show them off your website? Because I can. As a matter of fact, I can show you all the ones in my particular case for the Department of Public Health. Welcome to the Ministry of Sunshine, the Orwellian group that meets in the city and county of San Francisco to protect the city and county of San Francisco, but certainly not to get to the whole truth. Oh, Mr. Wolf, thank you for your part years ago in the HIPAA violation that we were going to have a hearing about that never happened. Thank you for allowing me to point that out, to continue to show how it doesn't work. It consistently fails. There's no follow-up by design. Thank you. I will continue to say it. This is a sham. We are the heroes. The other side that you've repeatedly made decisions against are the repeat felons and serial violators, but you don't give us any deference. Amazing, but typical. Thank you. Have a nice day. God bless.
Any other further public comment on the motion for reconsideration?
Members of the task force, Ray Hartz, Director, San Francisco Open Government, and I'm in support of the motion, and I believe the sentiments that have been expressed sort of tend to make me believe that the entire body is. As Ms. Member Wolf read the policy body, I think that what Mr. Clark said is definitely appropriate. 7.3 definitions policy body shall mean, and subsection 4 says any advisory board, commission, committee, or body created by the initiative of a policy body. And it sounds very clear that the new evidence, as well as your prior discussions, indicate that the Arts Commission created this advisory body, and therefore it is a policy body by definition of the ordinance. I think this is particularly true, as Member Moss said, to do this because, unfortunately, the Arts Commission has a long, long history of being here on numerous occasions, given their kind of strange interpretations of the law and their unwillingness to ask the task force, well, what does this mean so we can do this right? It seems to be, let's do it and hope nobody catches us doing it wrong. If you have another discussion, make it very clear that they are or are not a policy body or a passive meeting body. That gives the Arts Commission a clear understanding that the next time you set up a body like this, it is a policy body. If your commission sets it up, by definition of the law, it's a policy body. And unfortunately, with their past experience before the task force, they need to have direction, and letting it kind of slide and giving them kind of a wiggle room is not a good policy on a group that shows the wiggle room will be taken to bad purpose.
Any other public comment? Ma'am, your party to...
Can I respond at the end? I'd like the chance to respond at the end.
We're not providing rebuttals. This is your presentation and all the questions that were answered to provide us with the information, about this.
Factually untrue statements.
It's not our process during reconsideration to do that.
Thank you.
Today we're just reconsidering. We're just taking a motion whether to bring this item back to the task force for a further hearing of the details and the merits. We're not making a decision today except just to procedurally do that. Thank you. Member Josh Wolf.
I understand procedurally how there's no place for her to speak, but at the same time, this representative is different than the representative that will likely be there if we do decide to reconsider it. So I'm not sure that we shouldn't somehow create a space to add her testimony. That
if we reconsider this item, she'll have plenty of time and for us to ask a lot of questions at that point. Right now, this is purely procedural as to whether we agree that what the petitioner had brought forward is compelling enough. She had an opportunity to dispute that. The question is did that convince you? And so I don't want to prolong this process, this particular item any longer. I think we have enough testimony, enough public comment and information to make that determination at this time. I do want to say that that procedurally, under parliamentary procedure, Member Moss cannot make this motion because he didn't vote in the prevailing side. So I think it was Member Eldon who made the second.
Member Hinsey made the second on the motion to reconsider.
Member Hinsey made the second for reconsider. Okay, so I would just like to make this proper and have without going through the whole process again, I would just like a member from the prevailing side to make the motion and we can retain the second.
Through the chair. What was the voting record on this?
It was, ayes were 6, Eldon, Josh Wolf, member testified, Kanata, Hinsey, Highland. The noes were Moss, Fisher, and myself.
The noes were...
I can do it.
Yeah, so we just need a replacement for the motion.
Okay. I'd like to replace the motion.
Okay, is there any objection to that? Seeing no objection, okay, we'll take it at that. Everything else stays the same.
This is the motion to reconsider the complaint and to reschedule this matter for a future hearing date.
Okay.
Due to the
So
information being provided.
Before that, there was something else I wanted to say. The only reason why I was trying to put this to a little bit to task was because it has to be very clear. There has to be a bright line. And in order to bring a petition for reconsideration is serious. It's basically saying that we possibly could be wrong and that we didn't see or pay attention to certain information. So even though I voted no, and in the previous order of termination, it was very important for those that are supporting this motion to convince the rest of us, and for the petitioner to do the same thing, that this is absolutely information that will possibly change, that it's clear that it's possibly changed. Can't be any wiggle room. That's the purpose of this is a very high bar. So if you're going to vote to support the reconsideration today, it means this information is compelling, not somewhat compelling, not possibly compelling, but actually compelling, that it would change your vote, possibly change your vote when it comes back at another time. Okay? Just wanted to make that clear and for the public. Okay, go ahead, call the roll.
On that motion, Member Moss.
Yes.
Yes. Yes.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Member Fisher.
No.
Fisher, no. Member Hinsey.
Aye.
Hinsey, aye. Vice Chair Highland.
Aye.
Highland, aye. Member Eldon.
Aye.
Eldon, aye. Member Josh Wolf.
Aye.
Wolf, aye. Member Tesfa.
Aye.
Tesfa, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes. This matter will be scheduled for a hearing on a future date.
Thank you.
Next on the agenda is item number 5, public comment. Members of the public may address Sunshine Ordinance Task Force on matters that are within the task force jurisdiction, but not on today's agenda. I would also like to note that Ms. Ellen Sang, for item number 6, who is the authorized representative, has just arrived. However, the task force has already made a decision regarding the matter.
Matter's closed.
Sat here an hour to hear that.
Did she know that she was being moved?
She knew.
Yeah, through the chair, I have a question. Did she know that her item was being moved up in the agenda?
It was not her item.
Oh, never mind.
It was anonymous was the item.
We are on public comment at this time.
Public comment.
I just want the record to reflect that the last time I spoke, Ann Trickey, who I don't know from the Arts Commission, made a comment at the end that I was a liar. It was heard by other people sitting in the front row. So that kind of speaks to the mentality of the Arts Commission. So on July 12th, there was a street artists meeting. After the meeting was called to order, and after the gavel went down, Ann Trickey said, and I audio taped it, she was not going to tolerate slander, abuse, character attacks of staff at public meetings. If she felt that there was a menacing tone to public comment, the speaker would be ejected from the room and the public comment would be censored. I audio taped the entire meeting, and it appears on my audio. Her rant was about 10 minutes. When I suggested that she turn on her audio, it was about 15 minutes into the meeting. So the audio on the website didn't pick that up. But my audio recording did pick up her entire speech. To me, this is a clear violation of the Sunshine Task Force, and it goes against the will of the voters. When they voted the Sunshine Ordinance into law in 1990, it's outrageous that people, concerned citizens, have to come in here on a regular basis to hold staff members, particularly of the Arts Commission, accountable for their actions, because basically they don't care about the ordinance. And I'm still kind of stunned that Kate Patterson would continually verbally attack me as a response for sunshine requests. That's gone on for 5 years. I really don't understand it myself. So here's my public comment.
Members of the task force, Ray Hartz, Director, San Francisco Government. As you can see from this list, I've been doing this for a while. And people make comments, which I kind of let them roll off my back, about the fact that I'm harassing them, like Sue Blackman of the Library Commission likes to claim I'm harassing them. I think it would be harassment if I filed 50 complaints and lost them all. But if I file 50 complaints and win 33, I don't think that's harassment. I think it's simply substantiating a record. One of the things I have learned over the years, starting with my first public meeting in San Francisco at the Police Commission, was that members of commissions and boards in this city seem to feel they have the right to stop people from saying things, to interrupt them, to do all sorts of things. And I agree, under the law, they have the right to respond or remark on any comment someone makes after they are finished. But they do not have the right to interrupt them, to challenge them, and no matter what good intention they might have, they would be better advised to be quiet, let the person make their comment, and then if they have something they want to say, respond in an appropriate way. The reason I say that is the fact that the First Amendment states that, among other things, that government may make no laws infringing the freedom of speech under the First Amendment. A statute, I'm having a hard time reading this, a statute or ordinance that burdens speech based on its content generally must be necessary to serve a compelling state interest in order to pass constitutional muster. And most of the time, people will on a board or commission will say, "Oh, you can't say that because it's just like was mentioned previously, Art Commission. If somebody says something about this, that, or the other, I'll have them ejected." That's the purpose of a public meeting. And like it or not, telling people that they can or cannot use certain words or certain phrases or their tone of their voice or anything else is violating their First Amendment rights. Using the excuse that you used a bad word and I want to protect the children in the audience is not the job of any member of the board or commission. If you want to say after the fact that you don't like the fact that they used an inappropriate word, you're certainly free to do that, but you're not entitled to interrupt them, to stop them, or certainly not to eject them. I had an interesting conversation with Peter Keene, who is now the present chairperson of the Ethics Commission. And I asked him a brief question. I said, I've gone before lots of boards and commissions and said that the comments at these public meetings are constitutionally protected political free speech, and nobody says anything. And you know what his response was? How or why could they?
Hello, once again, I'm here for the public comment. My name is Jason Grant Garza, and here's a list of all the ones that I've been through against, the Department of Public Health, the Sheriff's Office, et cetera, in regard to everything that I brought in. The pattern here is rinse, lather, and repeat. There's never a precedent. The serial violators keep coming back. The heroes, which is myself, Mr. Hartz, and others keep bringing people forward. This spans probably 8 to 10 years of decisions made, where I was the one who was correct. However, you guys have this in your file because I sent it to you. I just want to put it on public record and on YouTube because all these things are going on YouTube to show the people why there is no hope at the Ministry of Sunshine. For people to have hope when you guys provide no remedy. As a matter of fact, the very first one was sent up for official misconduct. If you'll look on that page. I believe the name was Eileen Shields. Would you like to see the paperwork for that failure? Or would you like to see the article that was written about the 14 to 16 times you guys send people to ethics and nothing came of it because you guys are a failure? Oh, that's right. Or would you like to know about the nuclear winter when, the majority of the people who had any institutional knowledge were kind of knocked off because, the Sunshine Task Force wasn't here. So all the people who had valid arguments just fell by the wayside. You guys, to sit in this position here and to try to, like Mr. Hart said earlier, claim that you're assisting us, it's obvious what you're doing. It's on YouTube. I've got videos from before when I asked the same questions about my medical records and everything else, only to be played with the same lies, the same outs, and you guys bending over backwards to accommodate the perps. Well, all I can say is have a nice day. God bless. I'll continue to come back. I'll continue to make films. I'll continue to do the correct thing in front of this ministry of sunshine, where there is no sun, where all there is obscuring of the facts, twisting the narrative, changing word definitions, different interpretations of what the law states. Excuse me. We're all human beings. We've all read the Webster's Dictionary. We all know simple English. What are you doing? What is the Ministry of Sunshine doing? I'm glad I was able to ask the question, and I'm very happy to be able to post this on YouTube. Thank you. Have a nice day.
Any other public comment?
Good evening. My name is Alan Sang. The complainant for case number 17027 authorized me to representing him because he's not feeling well. And I come because of the number item 6. I was here when your cases number 3 was going on. So I wasn't late. I was on time. I representing the complainant is acceptable by your Sunshine Committee. And then in the past, I attended several meetings, and the respondent was late. They would not come up at the first time the hearing started, but they come in when the case was called. But you don't change the case to be heard in the first. If you in the beginning you saw somebody wasn't there, so that's not fair. It's not the complainant is not here because he already authorized me to represent him because he's not feeling well, and then as I said, you accepted that I can representing him. I come in timely before the case is heard. You switch the without notification to the complainant or to the public. I can, that's not fair. I mean, he should have the chance to answer your question and present his case. I can answer the question for him. So now, I guess the respondent's gone. I don't know what happened, okay? Because I just tell you that I come here timely, and then I have authorization to represent the complainant. I don't think that you should take away his right to speak before you and answer your questions. Am I prepared to do that? So I don't think that you can do that. I think it's wrong for you to treat it differently to the complainant. If they don't show up in the beginning, they're okay as long as they show up at the hearing. I think even the court will call and they don't show up, and then they still ask them not to go and then wait until later. So this is not fair. Yeah, I think this is wrong against your own policy. Why don't you publish this is the schedule to be heard the case, and then you switch it without any notification. And then I present long before the case is called, I think that you should let the case to be heard before you. Thank you.
So I just want to respond to you, Ms. Sang.
Yeah.
First of all, we don't know who Anonymous is, and we've gotten no information or contact from Anonymous that they may be late or that they want the item to be adjusted as far as timing on the agenda at all. We don't know that you are officially representing him. We have no notice of this. I've not seen this.
No.
This is today's date. So we need. Hold on. Okay. I gave you an opportunity. Okay.
Thank you.
So let me give me the opportunity to speak to explain this. So prior to this meeting, this item was scheduled for a previous meeting, and the complainant had contacted us directly and said, I cannot make that meeting. Can you continue it to the next meeting? So it didn't even show up on our agenda in July.
Oh,
okay. I know. So, but we have to go by what we're presented.
Yes.
I understand there could be other extenuating circumstances. We don't know what they are until you're telling us right now, which is kind of late in the game. So we have to try to move things along. So we don't know. Yeah, well, and if you appear, we only can take that as you're not the party, you're not the complainant, but you're a witness or a person that has additional facts or evidence. If I don't know about official representation on behalf of a complainant. We don't usually have that unless there's an attorney of record involved for the complainant themselves, and that person has been authorized because they have power of attorney. So that's kind of where things are at right now, and based upon what we had heard and based upon the information that we already had, I'm not sure that the outcome would be any different. Could be, I'm not sure. At this point in time, since the determination was made, Anonymous is available to take advantage of our reconsideration process and have the item reconsidered, and we can then actually hear the item again.
Victor, can you be telling honestly, you received the email from him, right? According to what I was told by the complainant. Yeah, approximately 3:30 today.
Yeah, but we can't go if we didn't get it here, and we don't know that that's going to be. I've not seen this. Victor, have you seen this document that's up on the screen?
3:30.
Yes, I did state we received the email, but I did not have time to do anything with it. It showed up in our mailbox. I saw it on
at 3:30. Oh, when you came in the room here?
Yes.
Okay, so
I was here when I saw it.
I don't think it's a little inappropriate to for that kind of thing. I'm just feeling a little uncomfortable on the spot unless somebody is here that or it's been provided to us at least a day before the meeting.
Okay, I would like you to have the policy set straight, apply to everybody.
But we've done this many times where we've adjusted the agenda, and if the either party is not here, the person named, the party, the actual person who is named not here, then we take the choice of whether to continue the item or whether to move forward on the item.
I understand you have that option.
That's our policy.
Yeah, your policy is not, Victor, according to what I heard, he says that it's okay. Actually, he sent an email to the supervisor and asked them, respondent can have a representative. Why the complainant, like him, is OH, cannot have a... Then Victor's response is, yes, you can. Prior to the hearing, then you can just send it.
These are our rules, okay? And that's the way we operate our our process. Not somebody else does not tell us how to run our
No,
how
I
our
understand.
thing.
But Victor sent him an email and says, as long you says you authorize a person, give the name, and then he can answer the questions. And prior to the hearing, that's what he was trying to come. He's just sick. Okay, he's really senior. So I understand.
Okay, Ms. Sank, let me hear from some of the other colleagues, and then we'll try to sort this out. Member Josh Wolf first, then Member Eldon, then Member Tesfaye.
So apologies to my colleagues for being late, and I'm just curious why we decided to dispose of this item prior to it arriving at item 6. After having heard testimony, I'm just sort of wondering why we didn't get to 6 and then go, is anonymous here, why we made that determination at the beginning of the meeting. And the second point I'd like to make is, yes, anonymous could utilize the reconsideration process if we decide it's closed, but they're anonymous, so they could also just file another complaint, which would have a different bar to reopen this, because anyone could file a complaint about this matter, which might be a better process for them to explore.
Okay, before Member Eldon, I just want to let the chair of the complaint committee respond to that.
I have to leave at 7 p.m., and I would be the person introducing the item, so we wanted to make sure that I was here to do the presentation. And so that's why I brought it up during agenda changes, because all parties have to be present when agenda changes come up on the agenda to speak to whether an item can be moved or not. Mr. Clark spoke at that time. And so that's why I brought it up at that time. All parties have to be here when agenda changes come up on the agenda. And then they can choose to come back later or say, I need to speak up now, or what have you.
Member Eldon.
So just
in the
to be clear, the reason we changed the agenda was because our member who needed to present about this was not going to be able to be there later on. It had nothing to do with the respondent.
Yeah,
as you described.
Yeah, I know that he also have a chance, and then even though he's not feeling well, he tried very hard to come, but he's still not feeling well, and he asked me and tell me that he notified your committee according to the Victor's information, and as long as before the hearing. So I don't think that. Well, you can make your decision. I have nothing against you, okay? I thank you for your time to serve the public. But at the meantime, going through this one, I just think that you change the things against what your committee advised him. This is something else. You might say that, I never know myself. You just changed it without everybody there. Next time, if the respondent, department doesn't show up, then
no, the reason we changed this was not because of the respondent. We changed the time of this because our member who needed to present about this has to leave at 7, and if we had waited, Member Tesfaye would not be able to present about it, and it would have had to be continued anyway.
Is it
so that's why we changed it.
Yeah, I understand what you're saying, but it's more important the person tried so hard to have the case file, and then want to have the chance to speak, and then just because somebody, your members not always here all the time. I mean, sometimes you have a member absent too.
Ms. Sang, let me give you a quick summary of what we talked about when you weren't here. That'll help you.
Okay.
We found that Anonymous was complaining with the information that was provided. Our job here is just to make sure the information is provided. That's why Chair Wolf was saying, even if you were here, it probably wasn't going to affect that decision we made. You have the option, you can file a petition, or you can go back to Mr. Anonymous, and together you can file another petition and make it a stronger one than what we've seen here. That would be our advice to you.
Save everybody's time. So I can make a complaint, and then he can make a complaint, or he can file reconsideration. Is it what I understood?
Reconsideration, or even a new one, which might be a better way of doing it. But talk to Victor; he can help you with that as well. How to what you're dealing with is, we had an internal decision here to take this out of order, but based on what we heard tonight, I think it might be in your interest to talk to Victor about how to create a new complaint. That might be better.
Okay.
And for the future, Victor can help you, and he did let us know about this email, and I knew that you weren't here.
Yeah.
But if someone is sending you as their representative, you need to make sure that you are present when item 1 is called to see if there are any agenda changes.
I'm sorry,
because your
I didn't
item
know.
can be moved. So if you have agreed to represent someone, you need to be there when item 1 is there about agenda changes, because things can come up that need to be discussed, and we always give the public the opportunity to comment on any agenda changes that occur, so that someone could speak to that reason.
Actually, I was outside because I need to do the bathroom so much because I'm under medication. That's why I didn't come in, because I was watching. It's not called yet. So I was watching, until the first one starting the police, and then I said, I better come in, and then, yeah.
Yeah, so, just so you know, our
Yeah.
agenda is not necessarily a time schedule.
I understand.
Okay, it's, we're not a court that has this very specific kind of docket kind of system in that kind of way. So we don't do it that often, but sometimes for certain circumstances we will. I would just offer this, just on basic parliamentary procedure, because we're still in the same meeting. If any member wanted to make a motion to reconsider that item, we can. I'm making, we will finish public comment, but absolutely, but we will, I can, interjecting this procedure right now. Member Joshua.
What exactly was the disposition that occurred with this case? Because
what was the determination? No violation.
Was there a vote? What exactly?
Yes, there was a vote.
And okay.
It was unanimous
to
find no violation.
Okay, thanks.
So, the motion for reconsideration doesn't have to happen right now. If at some time during the meeting you feel compelled to do so, be my guest. But frankly, it's saying because the other party isn't here, we would have to reschedule the meeting anyway, the hearing anyway.
Okay, so what? I just want to report to him. What is it?
He can do. Two things can happen. One is he can make a petition for reconsideration, which we already had one today for another issue. That would just bring him or you back here to provide information that might compel us to reconsider the item, and then it would be rescheduled anyway for another time so that both parties could be here. Okay? And then the hearing would almost like it would continue from the point just before the vote was taken.
So does he have the opportunity to present his
At that
case?
point, yes. At that point, we will continue. The item will be as if a vote wasn't taken yet.
Okay. As a public member, I would really appreciate that if when you send the email to the members, the complainant, the public, give them more helpful information. Like when you say prior to him, as long prior, she tried hard to see
I
for the prior.
understand, but he already requested a continuation on this item once before.
Oh yeah,
and so there's only so many times that we'll do that. We've had people that we've accommodated 3, 4, 5 times for continuations. It creates a backlog for us. So we will move ahead on an item. That's the purpose of the reconsideration. That's like an appeal of our decision. No other place in this building necessarily does that, except maybe the Board of Appeals, which is a different kind of process, and you know about them.
Yeah,
so
I do.
Yeah, so I would just say we need to move on. Two things: either anonymous can petition for reconsideration, or one of the members here before the end of the meeting can make a motion for reconsideration. And then we'll take it from there.
I understand your point, and then I appreciate your time. I just think that so far I can hear it's not fair to the complainant him, and the first continues because that was automatic anyway. If he requested timely, it's not something. I just read the record.
Thank
Thank you.
Appreciate
So
it.
I can file a complaint with ask Victor's help.
Yeah, any other person other than anonymous can file a complaint on the same item.
All right, thank you.
Any other public comment?
But if you stuck to the original agenda, you'd be hearing it before 7, and whoever testified would have been here.
Thank you.
We don't know.
Thank you.
Yeah, and I'm not sure that that you have to be an attorney to represent somebody who's sick right before the. I mean, if you're sick, you're sick. You're not going to have a day's notice. So, but anyway, my name's Diane, and my public comment goes to kind of the patterns of behaviors that have been obviously shown here today, as well as what will be shown here later, and the need for this body to request a hearing in front of the Board of Supervisors to kind of determine policy-making bodies so that they can ensure that policies are in sync with state, federal, international, and local laws, actual laws. Specifically in the medical industry, where you have to turn off your cell phone and you can't video record, are contradictory to ADA and other constitutional laws and rights, yet there's policy in public entities that forbade it and actually punish people who are injured, seeking medical attention, and assaulted, where their information is, their video was actually deleted from their personal phone, where no record of them being admitted or triaged existed, because he was thrown out prior to even getting to that point of signing in for his medical issues, which are emergent. This was 3 months ago. Since then, he's lost 35 pounds. I'm very concerned about his health, and I'm pleading with this body to do the right thing. I know you don't have much teeth. You really can't do anything but say, okay, provide the information. But to hold a hearing in front of the Board of Supervisors to request specific help with consequences and change and training for city employees at public institutions to undo the programming and the wrong processes, so that people who are injured and in need of medical help, people who pay into the Arts Commission, the Street Artist Program is a fee-based program paid for by these artists. Yet the city, when it gets involved, doesn't. I've been a party to that too. I did a whole whistleblower on the Street Artist Program. That was a sham. Ray Hartz, I love this guy. Thank you, Ray, because you're succinct, you're accurate, 100%, and you keep coming back here calmly. And I don't know how people can be so calm. This is humanity. I mean, this is what our society is. Well, we'll let that one slide. Oh, well, we can adjust the agenda. We rely on your processes. And when you set an agenda and you start the hearing, the agenda should stay the same. People who are on 6, 7, and 8 should be able to go use the restroom, go to the water fountain, and not come back to find that 8 was heard before 3 and gone, or whatever the case may be. Somebody gets sick, this is not a court. It's not a hearing. They should be able to send a representative. They did provide notice. It was short notice. That's because he was ill and couldn't stomach it, probably. It's very traumatic for people to keep coming back. Thank you.
Any other public comment? Seeing no public comment is closed. Let's call the next item, please.
Next on the agenda is item number 7, file number 17072, complaint filed by Marvin Lambert against Historic Preservation Commission for allegedly violating Administrative Code Section 67.16 by failing to make draft minutes of each meeting available for inspection and copying upon request no later than 10 working days after the meeting. This is regarding the June 7, 2017 meeting. On July 10, 2017, the Compliance Amendments Committee determined that the task force has jurisdiction and referred it to the task force with the recommendation to find a violation of Section 67.16. The appearance of the parties at today's hearing was waived as the parties agreed that a violation did occur.
CAC Chair Kanata.
Yeah, we heard this, and the planning department staff is also the staff for the Historical Preservation Committee. They were represented, and both parties agreed that the planning department staff was late in providing the draft minutes. They agreed to the violation, and that's why we recommended the violation.
Okay, thank you. Are both parties here? Is planning department here?
Planning department is not present.
Not here. Okay, that's fine. The petitioner, please come forward. Just set him for 5 minutes. Jurisdiction. Yeah, he already mentioned it. Yeah. Go ahead, sir.
Yeah, I'm Marvin Lambert. So, yeah, I agree that they were in violation, but I don't think it's proper to say they were late. They had no intention of sending me the minutes, and I don't see what the enforcement or what the punishment is here. I just don't understand that. I don't understand a lot about the process. I'm kind of learning as I go along. I just happened to get into an issue that's very important to me, and I found out that staff, this is really about staff trying to run an operation in secrecy without even visibility to the commission in this case. And I more or less got involved and caught their hand in the cookie jar. And oh, by the way, in the end of this thing, the whole proposed project has been withdrawn. That's the result of this. I was able to find out about it at the last minute, but this was going to be an installation in a mini park, and it was going to go on with no public disclosure of any kind. So it's been removed. So what I don't understand about the process here, and I just don't understand it. For instance, when I asked for the minutes, that was just fact-finding. What happened here? Because I went to an HPC meeting, couldn't figure out what was going on. I said, well, let's look at the minutes. And then when I saw the minutes, which I saw was not accurate of what happened at the meeting, I went on in my complaint then, the documentation, I filled out an extensive complaint which has to do with basically staff operating trying to operate in the dark. So my other question is, much of this is violation of the spirit of the ordinance as well as the Brown Act. And it's not clear to me how somebody brings a complaint before this board when it's a violation of the spirit of the law and not something that's very specific like this document, that document, or whatever. And the other thing about the document thing I find interesting is I've subsequently gone on and asked for more information. You do get copies of emails. And it seems like if staff is trying to hide something, they won't send emails because you're apparently not privy to verbal communications, which I've asked for. And I'll just tee up something. My next complaint, which I'm working on, I assume this is going to be a complaint, is I'm asking for more information what really happened here. Staff is claiming attorney-client privilege, because the city attorney was brought in on this deal before they eventually decided they'd withdraw the item. So they're hiding information from me, yet they're sharing it with the other member of the public who's proposed the project. So I just have a lot of questions here, how your process works. Specifically, I guess just to review if it's a violation of the spirit of the law, and then why, in my extensive complaint, why, I know you mentioned that to me at the meeting, I just don't comprehend why only the minutes issue, which was obvious, and that I guess I should have immediately filed another complaint as soon as I got the minutes, because as soon as your complaint went out there, oh, they sent me the minutes. But I'm sure they had no intention of sending me the minutes. Thank you.
Thank you. Are any persons or witnesses on behalf of the petitioner providing additional facts or evidence? Seeing none, is the respondent present? Respondent is not present. Are there any persons or witnesses providing any facts or evidence on behalf of the respondent? Seeing none. Members?
From what I remember of this case, it was that the only substantive issue that we could have ruled on at that point was the fact that they were late providing the minutes. The complainant eventually got the minutes, and as to the content of the minutes, I mean,
Sir, you'll have to wait until somebody calls you up. If you don't mind.
So that was my recollection of the whole case. The rest of the issues seem to be more with the process that the planning department staff was using, which we had nothing to rule on at that point.
Let me ask you a question. During the complaint hearing, did the respondent agree that they did not make the minutes available 10 days after the meeting?
Absolutely.
Okay.
Yeah.
Okay. Member Moss?
I was just going to echo that was my recollection as well. I just wanted to clarify that it wasn't that they were like, it wasn't like he put in a sunshine request and they were late. We were actually looking at 6716, and that requires these draft minutes to be available within 10 days. So just a point of clarification.
Okay. Thank you. Any other questions, answers, questions for the petitioner at all? Okay. Rebuttals, the respondent will come first. The respondent is not present. Mr. Lambert, you have 3 minutes for rebuttals. Any rebuttals?
Well, I guess the thing I'd like to know is there was nothing substantive that you could respond to. I made a lot of substantive complaints, but they weren't things, as I read the Sunshine Ordinance, there's a great first paragraph, as just like in the Brown Act. And oh, by the way, we'll just throw that away. Why is that even there if we can't bring a complaint based on the first paragraph? We have to go down and identify a particular. I don't see how the law can anticipate every particular type violation. And I think if you read my complaint, there's a lot of substance there. It just didn't match up with your list of particulars. But clearly, there's an issue here of staff. This is, I guess, in the broadest terms, the tyranny of the bureaucracy. They operate by their own rules, and we all know there's a deal with the commission. They have to depend on staff because they show up twice a month and get the facts, so they have to trust staff. But when staff is working outside the lines, then how do we bring them back in? And that's what the case is. Staff got too cozy with an outside proposer here, and they kind of formed a cozy little partnership. They're just going to move this project through. They're going to put this ridiculous installation into a little mini park, which is part of a historical district, and that's part and parcel of the substance. And it's a question of whether a certificate of appropriate is needed, and that's where I got involved with the thing and stopped it. And then they undoubtedly realized when this is now in the light of day, they're not going to go through with this thing, or at least they're going to pull back and do another strategy. So that's where I am. I think this Sunshine Ordinance, what does it mean if you can only relate it to getting documents or not getting documents? And a lot of that, they can quit writing emails to each other and just have phone conversations. So seems like, I don't know, somebody said, and then the enforcement, I've been reading on the enforcement seems to be nothing here. You're going to put something on your website, put something on their website, and of course, since this has been withdrawn, then there's nothing punitive for what they did. They got caught with their hand in the cookie jar. Oh, excuse me. And now nothing happens. There's no repercussion for that because they've stopped the behavior. And that seems to be all your enforcement addresses.
Member Eldon.
If I may, sir. We're limited by the Sunshine Ordinance that was passed in the 90s. They're working on amendments to it. we are a part of that process. There aren't many things like this that exist in other cities around the country, so we are, we're doing the best with what we have, and given that we are bound by what's written down, what would you like us what could you consider us doing that's within our means?
Well,
we're not. I mean, we can't make laws, right? We can't.
I don't have a problem with the Sunshine Ordinance, but I'm not an attorney, but I have read that violations of the spirit of the law are worse than violations of the particulars. And if staff is running outside the lines, somehow we have to be able to control staff when they kind of become a government of their own. And they exceeded their authority on this process. They made decisions they shouldn't have. They created a cozy relationship with the project proposer, and they thought they could run this right through without any disclosure. So the law is all there. The point is apparently you don't enforce anything unless it's very specific.
I mean, that's every law, right? You can't just.
I don't know, but I think.
You can't just say someone is bad. You have to get them on a specific, right? And so, I mean, I'm trying to just talk this out with you. Because
Are you an attorney?
No, of course not.
Well, I guess we need some attorneys, but I do read a little bit, and there are cases where people have gone to the Supreme Court that have been determined based on violation of the spirit of the law.
We're a quasi-legal body.
Okay.
Right?
Okay. Let's move on. Member testify.
I'd like to make a motion.
Sure.
I'd like to make a motion for a violation of 67.16 for failure to make draft minutes available 10 working days after a meeting.
Second.
Okay, it's been moved by Member Tesfaye, second by Member Hinsey. I've got. I wanted to make some comments and questions, but I can do that here. So the complaint was, and correct me if I'm wrong, was that Mr. Lambert had requested a copy of the draft minutes, okay? And the minutes, that's number one. Number two, the minutes were not complied with regards to 6716. And 6716 is purely just the operation of whether minutes were created and posted by the originating body. It has nothing to do with the request. Okay? Mr. Lambert made a request. That's a 6721. And under 6721E, upon determination if the record is public, the Sunshine Task Force should immediately order the custodian of the public record to comply with the person's request. If the custodian refuses or fails to comply with any such order within 5 days, the Sunshine Task Force shall notify the district attorney or the attorney general, whom may take whatever measures he or she deems necessary to ensure compliance with the provisions of this ordinance. That is literally, except for willful failure, it's the only enforcement that this body has to make a directive. Okay? Now, the fact that the minutes were released before it actually came to this body, I can't say it necessarily applies as far as the enforcement part, but I do see a violation of 6721 because that's really the heart of the matter here. Primarily, the requester made a request for the minutes. The minutes were not provided because they were either not created or they were pulled. In addition to that, because they were not made available to the public within 10 days after the meeting, that's an additional violation. So I would respectfully request that 6721 be added to this motion. Member Moss.
Okay, so just to be clear, to make sure I understood this, so the request was made on June 22nd, and the complaint was filed on June 27th. So only 5 days passed between filing the request and the complaint being made. So I think that they would have, it wasn't an IDR as I understand it, so it would have been 10 days, would not?
It would have been 10 days.
Right, so if you can't file a complaint prior to the 10 days elapsing on the thought that they're going to violate it. And they may have, I don't know what the date was where the minutes were provided, but I think that if he'd waited a few more days and filed the complaint, then we could we can
Okay.
discuss it. It just seems weird to have this preemptive complaint
Okay.
filed, which I think is one of the things we discussed. During
Yes,
the
that's why I
committee.
saw that in your notes.
Yeah.
Or I saw that in some notes, in the notes that, that you guys had discussed that point. And so that's why you had limited it to the 67.16.
Okay, fair enough. Okay, public comment on this item.
Members of the task force, Ray Hartz, Director, San Francisco Open Government. I have to say I disagree with Member Moss in the fact that I've dealt with the library a long time, and I know that there are certain things when I put in a public records request, they're not going to respond, and they're not going to do it on a timely basis. So I don't see anything in the law or know anything in the law that says I can't, when I have a reasonable belief that they're not going to comply, even if I wait the 10 days. If I file it after 5 days or 6 days, and then they do respond on the 9th or 10th day, I can always pull it. But if there is no requirement in the law that says I have to wait for them to get the full length of time to respond before I can file the complaint, I think the facts should be what's considered. If he filed the request and they waited 10 days and still had not replied, and then sent him made the minutes available on the 15th day, they still violated the law. And the simple fact that he chose to not wait to file the complaint should not be held against him. Like I said, I've dealt with the library, and there are certain things, especially as it relates to the Friends, that when I ask them, I know they're not going to respond. And I don't see why I should sit and twiddle my thumbs for 10 days based on the idea that they have 10 days to respond. If they have 10 days and they respond within the days, I can always say, well, surprise me, and I can withdraw the complaint. But I don't see anything in the ordinance that says any length of time as to when I can file a complaint. So I think his filing of the complaint after a few days, although it might be different than what you're used to, is not any reason to not accept that additional violation.
Any other public comment?
Yes, hi. Once again, my name is Jason. Hold on, please. Once again, my name is Jason Grant Garza, and I'm before the robust committee of the Ministry of Sunshine. The prior person who was up here with a complaint spoke very eloquent about the spirit of sunshine and how there's no enforcement and everything I've continued to say. It seems that, had you guys been doing a better job of maybe enforcement, this place might be filled. But considering, everybody knows it's a sham, I think the lack of participation speaks volumes. Also, where were the respondents to the complainant? Isn't this official misconduct if they didn't show? Didn't he have to show according to whatever agenda item you sent? I know in my item, which is coming up, I have to be here and the respondents have to be here. So if they're not here, are you going to find them in official misconduct? Please, I want to know. Truly, I do. Who are you here for, Ministry of Sunshine? 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 Where were the respondents? What is the consequence? What is your bite? What is your authority? Oh, I forgot. You're powerless. You only provide illusion, propaganda. Oh, that's right. You're the Ministry of Sunshine. It's not real. It's an illusion. Thank you. This will go on YouTube with all the rest. Mr. Hartz is going to have his come up. What's it going to be? 10, 20 orders of determination that you've repeatedly failed upon? Can't wait to videotape that also for YouTube. Enjoy. Have a nice day. Sleep well tonight, knowing that everything you've said and done is not real. It holds no weight. Will accomplish nothing. But I guess you guys can just look beautiful in the newspaper and profess how much you care and how helpful you are and everything else. Well, I only have 2 words to say to that. Bullshit.
Any other public comment on this item?
This case definitely supports exactly what I was saying before. I mean, what can this body do to inform, train, unprogram city departments to better understand? I know they have to fill out a report. I mean, as a consequence of not providing it in the first place, that's misconduct. Not showing up, that's misconduct. They have to sign their annual, I took the Sunshine Task Force thing. It's a form, it's a test, but there's no follow-up after that. They have to do it once a year. There's got to be something that you guys can do to help articulate how important this is. That when the public asks for a public record, they need to provide it, and they need to provide it ASAP. Otherwise, I mean, why be here? You're just prolonging the agony and re-injuring people, especially by not doing anything or continuing or come back or, finding there was no violation because they submitted it after the fact. There is a violation. There should be a consequence. What is the consequence? You found there's a violation? You got to get more teeth. Board of Supervisor hearing, city attorney opinion. Otherwise, what's the point other than to distract from and use up time to actually file charges against the city and city employees? I mean, you're kind of set up to defeat any kind of lawsuit against the city for violating the law by determining there was no violation, even though there was, just because they handed it in after the fact. The implications and the outcomes of these decisions and these lack of teeth, you have no idea. No idea the human cost you're racking up. But I don't envy you, but thank you for sitting there.
Any other public comment on this motion? Seeing none, I would move to amend the motion to include 6721 because there was a request that was made, and if after 10 days there was either no response or there was the information was not responsive to the requester, then I think that actually applies. The fact that they supplied it 5 days later after the complainant, actually the person made the complaint, I think is of no consequence. I made a motion. Is there a second?
Second.
So moved by myself, Chair Wolf, second by Member Eldon.
Sorry.
Comment.
Can I move to continue this? Because we had instructed the respondents that because there seemed to be consensus on the violation that they did not need to attend this meeting. If we're going to introduce a new violation, then they should have a chance to respond to that.
Yeah, that's in the notes because they agreed that they had made the violation, that they had made the 67.16 violation.
Well, they could be here to defend themselves. It's not a requirement for them to be here, but if they felt compelled for it to defend themselves on it, I don't know that it makes much of a difference because the actual complaint is on the request, and that the information was not provided. And
the original complaint was specifically about the minutes section of the ordinance.
I'm looking at the complainants on page 190. On page 186, it says staff did not respond to my request for a copy of the draft minutes 10 days after the meeting of June 7th per 6716.
Right. And so we were looking at 6716 because that was the only applicable thing when the complaint was filed.
I disagree. What's applicable is that he made a request and the request was not complied with. That's primary. The fact that 6716 was not complied with doesn't require necessarily a complaint. That's not what the complaint is. If the complaint came to say that I was looking on the website for the minutes of this meeting and the minutes were not there, that's a 6716 would be appropriate for that complaint. I'm not disputing that already did not happen. But if a person does not have to make a request for the minutes, they can just cite it and say, the minutes aren't there. They should be there. That would be a pure violation of 6716. The specific complaint here is staff did not respond to my request. It's a 6721 request for a public document. If the public document had a completely other set of requirements, that may apply also, which obviously here the complainant did cite. That's appropriate. So hold on, let's get some other folks. Member Josh Wolf, did you have your hand up on this one?
Someone else, go ahead.
Go ahead, Member
I have a
Tesfaye.
comment and a question. My comment has to do with what Chair Wolf is explaining and what Member Moss had said earlier, that the statutory period that is available for the agency to respond had not come up. I know that there have been public speakers that disagree with that interpretation, that you need to wait until that period is up before filing your complaint. I disagree with that. I agree with what Member Moss has articulated. So that's my comment. And my question is, what happened to the motion that I made and that was seconded and that we took public comment on?
Because I made an amendment.
Yeah.
So the amendment has to be dealt with first.
Amendment to my motion?
Yes.
I didn't agree to that, or I didn't hear it seconded or anything like that.
It was seconded.
Yeah, I made it, and then it was seconded by Member Eldon.
Can I make a sort of point of clarification here?
Yes.
Okay, so I just went back to the records from our Compliance and Amendments Committee meeting, and according to the records that we have then, and I don't believe this is necessarily in the packet that we have this week, but the petitioner said that he, in his what he filed with us, that he received the draft minutes on June 27th. He had filed them on June 22nd. So the 10 days did not expire before he got that record. The only thing that they violated is that they didn't have them ready for inspection the moment that he requested it, because those were supposed to be available on June 10th. So during those 5 days, it's quite possible this agency didn't do the work and didn't have a responsive record because they were violating 67.16. But, the deadline had not passed by the time they passed that over on June 27th. Now, that still may ultimately be a violation that you're suggesting. I am mostly opposed to the due process element of it.
Member Josh Wolf.
I'm also concerned with the due process element, because it seems like essentially what happened is that if during the complaint committee both parties agree with the complaint, they're essentially leaving the door thinking that this is essentially wrapped and done, and this hearing is procedural because both parties agree. Now, in this case, it's appearing that there's a new complication, but the respondent wouldn't have a reason to anticipate that and come. So, perhaps we need to change this process of waiving it if they agree, but as it is now, they wouldn't have had a reason to come, and if we're expanding the violation, they should be aware that that's happening and have an opportunity to respond.
Okay, I appreciate that. It is not out of our jurisdiction to to overrule what a committee is recommending. Okay, if a committee overlooked something and now you have the full en banc, had the full brain trust involved in it, and another issue comes up, it's absolutely our responsibility if we find that through the course of the testimony or through the course of the presentation that there was additional violations. Now, I understand if you are concerned that the other party should have an opportunity to speak on whether the 6721 procedure, they should have an opportunity to speak on that, fine. I'm okay with that. You want to move, you want to have the item continued, I'm happy to do that. And that any motion to be made on that would take precedent over this vote right now, today. So, Member Canado.
Yeah, I'm just looking at the timeline here. I don't think this is a 6721. The meeting happened on June 7th. The request for minutes was sent on June 22nd, so the minutes should have been ready. But on June 22nd, a reply was made by the person who received the request saying that he's forwarding the reply to Christine Silva, and when the minutes are ready, they will be sent out. And they were sent out 6/27. So it's well within the 10 days of when the when the request was made.
Okay. All right. Fair enough. I'll rescind my motion.
Does that mean we're back to
Member the original motion, which is just on 6716.
Member Eldon agrees.
Okay.
Public comment has been taken.
Yep.
Can I
go to a vote?
On the motion to find a violation of 67.16, Member Canada.
Aye.
Canada, aye. Member Fisher. Aye. Fisher, aye. Member Hensy.
Aye.
Hensy, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Member Eldon.
Aye.
Eldon, aye. Member Josh Wolf.
Aye.
Wolf, aye. Member Tesfa.
Aye.
Tesfa, aye. Member Moss.
Aye.
Moss, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Call next.
Next
okay,
on the agenda.
Hold on. I think we need a 5-minute break. Bathroom break. We'll take a recess till 6:22. Bring the meeting back to order.
Better calculations.
Next on the agenda is item number 8, file number 17048. Complaint filed by Ray Hartz against Angela Calvillo, Clerk of the Board of Supervisors, for allegedly violating Administrative Code, Section 67.16 and 67.34, by willfully failing to place a written summary of public comment, if no more than 150 words, into the body of the minutes. This is regarding the March 14, 2017, and March 21, 2017 meeting.
Okay.
This was heard by the Education Outreach and Training Committee on June 10th. They determined that the task force has jurisdiction and referred it to the full task force with a recommendation to find a violation.
Okay. Where's Member Josh Wolf, Chair of EOTC? Can you provide us with a presentation on this?
Board of Supervisors.
Yeah,
Hartz versus Calvillo on not including the 150-word written summary into the inline of the minutes.
right. I was driving all day and haven't had a chance
Okay.
to look at the agenda.
Is there anybody else on EOT? Member Eldon, can you comment on this? It's pretty straightforward, but just if you have something to present, nothing? Okay, so let's move forward. Mr. Hartz, 5 minutes.
Members of the task force, don't pin it on me. It's not my fault we're back here again. 10 times the task force has ruled that in the minutes reads in the minutes, means in the minutes. The city attorney does this opining thing where he basically says, well, you can't read into it, and I'm not reading into it, and neither did the task force. If you read that section of the thing, if you submit a 150-word summary, it goes in the minutes. And I don't know what other definition of in the minutes is possible without reading something into it. Ms. Calvillo has already been found 4 times. The first time, as you'll see, it was in 2012. And then there have been subsequent, and this complaint is for 2 separate occasions, and it also was a complaint regarding knowingly and willfully. She has been told over and over and over and over again that in the minutes means in the minutes. Directives have been sent out by the task force to all city departments and commissions saying that in the minutes means in the minutes. And there are a couple of, basically, other than that, there are a couple short things I'd like to talk to you about. On page 273 of your packet, there is a letter there to Mr. Young from Wilson Ing on behalf of the clerk. And the city attorney's opining is down there in the sort of in the middle, and the second paragraph, which has the underlining, says, the speaker's summary of public comment may be placed in the text of the minutes for the agenda item or for general public comment if that is where the general public comment occurred, or at the end of the minutes, whether or not designated as an attachment. Now, the task force has found that second part they disagree with. In the minutes means in the minutes. But I would like you to look at the opining of the city attorney where he says or. That would include to me that either one is acceptable. And since the Library Commission, the Ethics Commission, the Police Commission, the Arts Commission, and 3 other commissions have all put the 150-word summary in the body of the minutes where it occurred in the flow of the events, then I don't see any question. Ms. Calvillo keeps bringing up these specious arguments about how it's her job to do this and that, but she has never once given a single example where putting the 150-word summary in the body of the minutes in any way impedes her or keeps her from doing her job. All of these other bodies have the same responsibilities to keep minutes and keep records. They put it in the minutes, and they don't seem to have any problem with it. Why does she? And since this is, as I said, this is also willful because this is the 5th time that I have brought this complaint, not the 5th time that she's failed to do it, the 5th time I brought a complaint about it. I would like you to also look at page 278. And this is about the 2 prior complaints, 16088 and 16089, and it's Ms. Calvillo's response. And the very last paragraph, the office of the clerk of the board conforms to all said requirements, and we hereby request that this matter be dismissed in order to conserve the resources of city staff and the task force, which obviously did not happen because those were both found in violation. Then she continues, if the Sunshine Ordinance Task Force disagrees with the information already provided and determinations, we request that the task force seek administrative remedies with a city attorney or the Ethics Commission. She has basically made a request that you send this to ethics. And I agree with it. And it is a willful violation because she has done it 5 times and she has shown she has no intention of changing it. And I think what she has failed to realize is she cites a couple of cases that went over there before, but she failed to realize that Mr. St. Croix, the fixer, is gone. There's a new sheriff in town, a new executive director of the Ethics Commission, and Peter Keene is a new chairperson. And I think they are much more impressed with the rule of law than Mr. St. Croix ever was. I would ask that you found Ms. Calvillo in violation for 2 times failing to place the minutes in the body of the summary, in the body of the minutes as ruled previously on many occasions by the task force, and that she does so willfully because she has, how many cases do you bring on the same issue before you say willful? And send it to the Ethics Commission, and I'll take it from there.
Are there any persons or witnesses on behalf of the complainant petitioner providing any additional facts or evidence? Seeing none, respondent? Respondent is not present. Any persons or witnesses providing any facts or evidence on behalf of the respondent? Seeing none, members? Member Moss.
Mr. Hartz, could you approach? So I find your argument really persuasive.
Thank you.
But I do want to ask a question. So,
sure.
The committee level had found a 6721E violation, and I believe that's for failing to send a representative to the hearing and explain the basis for its decision. And I went and I looked at 6721E, and that seems to be specifically about records withholding. Like the language is, an authorized representative of the custodian of public records shall attend any hearing and explain the basis for its decision to withhold the records requested. I am wondering whether, I know you believe that this is a willful violation, and you've made a strong case for that. You know, obviously the 150-word thing is the source of your complaint. I am wondering whether you agree with the committee that 6721E is the appropriate section for this.
Well, if that was in addition to 6716 and 6734, then yes.
So 6734 wasn't included in what the committee had recommended, according to my.
Well, I know it was not in the committee recommendation, but as Member Wolf said earlier,
yeah, no, I'm not disputing that you can bring it up and we can discuss it. What I'm asking, I'm just telling you what the decision from the committee's recommendation to us, which is not a final decision. I'm just saying that they had specifically said 6716 and 6721E. Well, and I'm just curious about your thoughts on the 6721E.
Look at page 272. Chair Wolf and all members of the SOTF, I made it clear that my complaint 17048 was also for violation of 6734 for willful failure.
Yeah, that's not the question I'm asking. I understand. That's not the point I'm trying to get. I'm trying to ask you what your thoughts are about the 6721E finding. Like, let's not talk about 6734, 6716. The recommendation from the committee was for a 6721E violation, and I'm wondering what your thoughts are.
For failing to send a representative?
Right.
I agree. Yes, that was a violation, an additional violation, and I'll be honest with you. My opinion on that, since that's kind of what you asked for, is the fact that they really don't have a leg to stand on. And if Ms. Calvillo really believed what she was arguing, she would show up here and she would tell you that. But she sent Mr. Ng, and Mr. Ng is like Sue Blackman from the Library Commission. She's the person you send to have people throw darts at because you don't want to go there because they might ask you a question that you don't want to answer.
Great. Can I ask DCA Cola the same question of whether 6721E can be
through the chair?
Is that okay? Whether 6721E can be applied to a issue relating a open meeting minutes related issue, or if it's narrowly limited to records withholding.
I mean, the plain language of it does say that it's regarding records requests. They didn't send a representative, but the complaint was more so geared towards sunshine-related issues that stemmed from a policy body meeting. So,
like, is there another section that says that if it's a complaint against on an open meeting
why don't
issue?
you do? I mean, if they're asking for willful, and you guys are going to go that route, then 67, then a violation of 6716 and or what was it? It was
34.
34.
And 6734, I think should be sufficient.
But
there's no sense.
I'm just curious because I don't think there is, but this might just be a flaw with the Sunshine Ordinance that is there anything requiring them to send a representative for an open meetings violation?
I think it's probably implied, but from the plain language of 6721E,
right?
Well, public information and public records. The plain language has it pertaining particularly to custodian of records and for records requests. So,
the idea for I'll support what DCA Cole is saying. The idea for 6721E is it's not so much whether a record. It's not so much whether the request was not necessarily complied with. It's whether the request was denied because it was not public. Okay, if you read the true language of it, it says that they should inform the petitioner for the request of the information as to whether any part of the record is public or not, and if they're denying access because they're stating that it's not public, and the Sunshine Task Force finds that it is public, then the next part starts to apply. I understand it's not written very well. Much of the original Sunshine Ordinance is not written very well. I mean, some of the stuff could have been broken out into sub-paragraphs to show kind of what the process would be. So I think that 6721 is wholly CPRA.
So not open meetings.
It's no. If the question becomes if somebody were to say, well, the 150-word written statement you submitted is not public, then that's a different question, okay? But we know that it's public because there's a provision that allows for it to be included. The question here is there a violation of whether the inclusion was properly processed or not? So I understand what you're saying.
The reason I'm asking this is because I don't want to make a motion that includes the committee's recommendation if that's an error, because if this is a process where we send it to ethics and the next step for ethics is litigation, and we've sent it with 3 violations, one of which may be erroneous, then that weakens the overall case. So
I would suggest then make separate motions for each one, okay? Because then if this body decides to send it to ethics, then they can determine which one, you can actually cite it, which one you think is the one that applies.
Well, I mean, I want to make a motion then, unless people want to discuss a little bit before.
Well, we haven't finished the process yet, so let's finish the process.
Sorry.
And then we'll get to it. Member Josh Wolf.
So the reason that 6721 was added the way that it was that there was a realization that there wasn't an adequate representative there, and there wasn't a close read to identify how this is potentially not inclusive of this particular complaint. And given the fact that, I'm a little iffy on the idea that they only need to send a representative under this particular angle, but for this particular case around the willful violation, I think that the strategic thing is to drop that from it and just do the 16 and.
So let me just just for the essence of the procedure, I'd like for us to get through rebuttals first, because that particular process is so that both parties have the ability to refute or agree with the original testimony, and then we can discuss the merits of what the violation should or should not be.
Well,
I think Member Moss is jumping the gun a little bit.
Well, I was sort of trying to. Member Moss's question was about what transpired in the.
I understand, but he's moving quickly to find violation of a section. So I want that get the information, ponder it, and then we'll have a full discussion about what motion should or should not be made. I'm just trying to compartmentalize.
No, I understand that. I'm just trying to sort of clarify what happened in the meeting that I wasn't quite prepared to. And Ray Hartz actually did a much better job than any summary I would have done anyhow.
Just want to make it kind of understandable for everybody.
Sure. So the last point I wanted to make was that the committee, if I remember correctly, identified that there was we were inclined to recommend the 16, but it didn't seem like there was necessarily unanimousness around the willful violation, so that's how it ended up recommended with a violation, but not addressing the willfulness or not, because we felt that that was a matter that was needed to be discussed amongst the full task force.
Okay. Anything else? Any other questions or clarifications? Okay. Let's go to rebuttals. The respondent is first. Respondent's not here. Petitioner.
Oh, I'm sorry.
Respondent's not here, but petitioner is here. 3 minutes.
Ray Hartz, Director, San Francisco Open Government. I would like you to ponder one question. if you think simply passing another violation of 6716 will take you any further with the clerk of the board than the other 4 prior violations, then I think you need to have some psychological counseling or something. Ms. Calvillo has made clear she is not going to listen to what you're telling her. She is not going to put them in the body of the minutes. Now, if you remember that list I showed you, the first decision in this matter was in 2010, 7 years ago. And the city attorney's office has had 7 years to write an actual legal opinion saying that it doesn't mean in the body of the minutes, and the task force is wrong, and he has not done that. And how many of you think that it isn't because he wouldn't like to, or do you believe, as I do, it's because he hasn't got a legal leg to stand on? The law clearly says if I submit the 150-word summary, or if you submit a 150-word summary, it will go in the body of the minutes. And I would like you all to consider sometime when you go to a school board meeting or some other meeting that's important to you, and you bring up an item over and over and they ignore you, and you at least want it in the record that you brought it up so that they can never say, oh, nobody said anything to us. That's what this 150-word summary is about. And the Sunshine Ordinance, as in all these types of laws, cannot detract from freedom of speech. It adds to not only the Constitution of the United States, the Constitution of the State of California, the Brown Act, but it gives the citizens of the city and county of San Francisco the additional option of ensuring that their free speech, their constitutionally protected political free speech, will show up in the minutes of the meeting, and that they cannot be abridged, misrepresented, or anything else, which is why I did this. For years, I would go to the Library Commission and I would say stuff, and then they would approve meeting minutes at the next meeting that said I said something different than what I actually said. And then they said, well, if you don't like the fact we did that, come back and complain it during next meeting's general public comment. So we've gone round and round, but the bottom line is after 10 times of deciding it, obviously the task force has taken a tack. And Ms. Calvillo has not agreed 4 prior occasions. She has not agreed on this occasion. I do not believe, honestly, she will agree. And it needs to go to ethics so that there can be a hearing as to why she is the only one who won't follow what the law specifically says.
Thank you. Okay, members, now let's talk about a motion.
Before we get to that, through the chair,
Yep.
I just wanted to give the newer members some perspective on this. This is something that's been circling for about 5 years, if not longer.
8.
Possibly 5 years that I remember, and not 6 years that I've been here before that. I think, and I don't want to put words in the clerk of the board's mouth, but they're basically falling to the fact that we comply with the Brown Act, which just says that you have to have minutes, you have to record which way the votes went, if people spoke, did they speak in support or against, and that is basically it. The Sunshine Charter is a bit more detailed than that. It talks about the 150-word summaries, about being placed in the minutes. I do remember, and this is purely on memory, that the clerk of the board felt that these 150-word summaries were not product of that meeting. She couldn't vouch for them, therefore they would have to appear below her signature in an addendum. And that was always their case. We felt at the time that that kind of defied the spirit of what meeting minutes should be about. You know, those comments should appear where they appeared and not, hundreds of pages later where someone would have to go and dig and find them, or worse yet, online. You'd have to see that it was, a hyperlink to take you down to those 150-word summaries. And we introduced motions 3, 4, 5 times, and in the end, the last go-around, we found no violations. We just couldn't get around the fact that they were included in the minutes. So just giving some institutional perspective there. And I voted for it once. Looking at everything now again. And I correct me if I'm wrong, I think we did send this to ethics, did we not? Perhaps Victor can tell us. Did this ever make it to ethics?
I don't recall.
I believe it. Maybe Mr. Hartz can answer that. I think it made it to ethics, and they kicked it out.
It made it to ethics, and ethics heard it while I was out of the state, and they also were themselves in violation at the time. So it was kind of a conflict of interest. How can you fairly hear a hearing regarding a matter where you've been found in violation for the same thing?
And did they also?
But one thing I want to point out is every one of those bodies, without taking any other action, now puts the 150-word summary in the minutes.
Agreed. A lot of the other departments have gone along and done that in the spirit. Still, does that mean that the clerk of the board doesn't have the option to do that? I don't think so. I think her letter is very persuasive if you go back and look at the history of this. And as she stated back in 2012, this is where we stand, and this is where we will stand. So we're kind of in an impasse. Anyway.
Member Motz and Member Johnson.
So I just had a question about how it works if we do send something to ethics. If we send something like this to ethics and ethics comes back disagreeing with us, does that then change precedence for us?
No, if you read 6734, all we can do is find willful failure. We can't find official misconduct. Right. That's not in our purview. So we find willful failure, we send it to ethics. Ethics then determines whether the act was willful failure or not. And if so, then they will determine whether it's official misconduct, and then it's in their wheelhouse. There's a whole, just in 2012, just before I left the task force, we had started a process to create a whole set of procedures for how these determinations are to be handled, because there was a dispute at the time when we were sending 6734 determinations to them that they would just re-adjudicate the entire case. And that's not what the Sunshine Ordinance says. Sunshine Ordinance specifies that the enforcement of it it's in the Ethics Commission. Now, the Ethics Commission created two sets of rules. One set of rule if you bring it directly to them, which means they handle it wholly. Most of the time they'll kick it back up to us sometimes, I think. I don't know how many times it's happened. But the other set was how they were to process a willful failure. So we make the determination, they provide the enforcement.
So just to make sure I understand, so if we send it to, the only thing they have jurisdiction over is the willful issue, not the underlying issue of the 150
That's right.
words.
They cannot re-adjudicate the case. That would be against their approved rules.
But if Mr. Hartz was to take this to a court, then that's a different story.
That's
altogether.
a different story, and lots of times you'll find, and this is for all the cases that we've heard today and every other before that if you were to try to take any CPRA or Brown Act or Sunshine Ordinance violation to court, the judge will ask, did you exercise the local process? This is the local process. And that provides a baseline or some foundation that is outside of the arguments of any of the parties. So this is an important part for that particular process. So, unfortunately, the voters did not agree to provide more enforcement. We hope maybe in the next round they will. That's kind of where things are at this point. So that's basically the procedure, what happened. That's the confines of which we can do. We cannot, I wish we could do more. I'm thinking many people would wish they could do more, but this is the confines of which, if we're going to be a nation of laws, then we have to abide within those confines. So I wanted to give a little history on this 6716 issue with regards to the inclusion of the written minutes, because a lot of you were not here at the time we first started hearing about this, and the first cases and determinations on this came up. And this is where Vice Chair Hyland had reminded me how important a database of our decisions is really important. Yes, thank you, Mr. Hartz, for providing your list. Where we came down to this is, I don't know if everybody has 6716 out. It's in, D.C. Acola was kind enough to put it in his memorandum. But the very last sentence says, any person speaking during a public comment period may supply a brief written summary of their comments, which shall, if no more than 150 words, be included in the minutes. We had very long discussions about what that means in the minutes. And we find that there is some encapsulation of the minutes when it's written down on a piece of paper. For instance, when you look at an agenda, at the very last item on the agenda is what? Adjournment. If anything is added after adjournment, is that part and parcel to the meeting? No, because the last time was adjournment. The meeting's over. Same thing more or less applies to minutes. At the end, when the minutes are done, at the end of the minutes is the end of the meeting. When it says in the minutes, then it should be in the body of the minutes and not as an addendum, a part of an appendix, places where they may not be found, because the public comment requirement for public comment is to provide a paraphrasing of the public comment itself. This provision provides to override that paraphrasing and to say, I don't want the minute producer, the person who creates the minutes, to paraphrase what I was saying. I want them to put in exactly what I meant to say. And here is 150 words to say that. And that was our determination. That has been the precedent that the Sunshine Task Force has made in every single determination on this particular issue. Okay, so had we had that database and you had the ability, or we had a listing of all these items that of all the previous decisions, you would have seen, and you could have gone back and listened to the playbacks of what the discussion was, and it's like a broken record every single time. So I am suggesting that this is, again, another one of those times that's happening. Member Josh Wolf.
I think that if we agree that there was a violation, it's a pretty difficult case to make. It's pretty difficult to make a case that it wasn't a willing violation. Each of these past history establishes that there is a conscious decision to engage in this process the way it is, and Wilson Ng's letter says that this is the decision that we've decided to make. So it is essentially we disagree with this determination. So if we want to move forward and say that the way that the clerk is doing it doesn't afford to fit in the minutes, which I'm inclined to do, I think that we have to call it a willing violation at this point, because anything else sort of doesn't make sense anymore.
Vice Chair Hyland and Member Kanata.
I had a question for D.C. Acola through the chair. Just going back and looking at some of the what's on record from 2012, the Brown Act imposes less requirements on minute keeping than our Sunshine Charter does. Just the language alone. In your opinion, legally, is it a valid position that the clerk of the board is taking, saying that we're complying with the Brown Act and that's all we need to do? We don't agree with your interpretation of the Sunshine Act. I mean, that's kind of the crux of the matter in my eyes.
I don't think they're saying that they're complying with the Brown Act and not the Sunshine Ordinance. I think they're saying that they're interpreting the Sunshine Ordinance as saying in the minutes is vague, and if they want to include it as an addendum, they're within their right to do so. My office has put out that good government guide that interprets it as being able to include it as an addendum or somewhere else other than directly in the body of the minutes where it sits. The complainant has on numerous occasions filed complaints alleging otherwise, and he wants this to go to ethics because he thinks maybe with new members at ethics, he'll get a ruling that goes in his favor, and that'll set new precedent for the city. So if you guys want to send this to ethics to get a determination from above that will change the way other city departments look at this issue, then that's what you need to do. But that's up to you.
Okay, thank you. And just to the task force, as referenced earlier, ethics has looked at this, and they have precedents. They ruled against it. So just a heads up. That shouldn't stop what we're going to do, but just to kind of give you the complete picture of where this issue has gone and what road it's traveled.
Member Kanata, then Member Joshua.
So it seems to me that this task force has attempted to set precedents with this, and that precedent being that in the minutes means in the minutes, not in an addendum or an attachment. And it seems like the clerk of the board has willfully ignored that precedent and has stated so in a letter saying, if you don't agree with me, take it to ethics. Since there's not much we can do to have any consequence to our rulings, and going to ethics is the only ruling we can make that has any consequence to a department that doesn't follow the Sunshine Ordinance, I don't think we have a choice but to send it to ethics for willful.
Through the chair, I believe you had a meeting with the clerk not too long ago. Was this something?
Did not come up. Member Joshua.
Vice Chair Hyland, you had said that ethics has precedence. Is there a rule of precedence in ethics rules, or are you just saying that they've made the decision around a similar issue in the past?
The exact case. They've basically ruled on this in the past.
Well, but I was asking whether precedence. Member Hart's. Sorry.
Finish your thought.
I'm just not certain that because ethics looks at an ethical violation, that you can really have a rule of precedence in the same way that other groups, such as a task force could, the Sunshine Task Force could.
Yeah,
I guess let me correct it. All I'm saying is they've dealt with this issue in the past, and they will no doubt look at their previous
They've
dealings.
only dealt with the issue of willful failure. They have not dealt with the issue of the core of the complaint.
Right.
Okay, so for me, this is not Ethics Commission's jurisdiction per se. Okay, unless somebody wants to bring a complaint directly to the Ethics Commission for them to make a determination on it, what we're discussing here is wholly within our jurisdiction, and it ends here. If you want to make an order of determination to find willful failure, then there's another process for that. But we don't have an oversight body. Our oversight body is the law, okay? And we have a sitting legal counsel here who can advise us, and there is the city attorney that can write a written opinion, which we haven't seen with regards to this issue, an official written opinion, because that will have the gravity of law, and then people can file a writ of mandamus to challenge that if they want in court. But that's the way the process works. So it's by sending it to ethics for determination of whether we're reading the law correctly or not, you're just giving away your power. You're just giving away the entire task force, the power of the task force. That's the way I see it. That we are it. That's what we're here for. There's 11 of us here. We're community members. The law is written for the public. The idea is does it serve the public's interest in that kind of way? And sometimes it does, and sometimes it doesn't. Yeah.
It seems to me that the reason for sending it to ethics is as follows. We, as the task force, have made, according to Mr. Hart's records, at least 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 determinations that it should be in the minutes, if I'm to read this graph correctly. And the city clerk has refused to give credence to our ruling, to accept it, and is basically thumbing her nose at it. maybe I should have just said that, but is refusing to follow it. And it seems to me that the purpose of referring it to ethics is to have ethics ask, the Sunshine Ordinance has made an order that you must do this. Why are you continuing to do this? And it empowers ethics to say that the clerk must comply with the repeated orders of the Sunshine Task Force. Yes, it's kind of putting the question of authority in the hands of ethics as to whether or not, what the Sunshine Task Force has decided overrides the Good Government Guide.
No, that's not correct. The purpose of the Ethics Commission is to determine whether the willful failure rises to official misconduct. That's their only purpose for the 6734 determination to be sent to them. You should look at their procedures. Their procedures specifically say that they're not to re-adjudicate the case. You're basically saying that the question is her denial, and based upon her reason to not comply with what the task force determines it should be, does that rise to official misconduct?
That's what I was trying
to Okay. But they will not then say the task force is wrong.
Right. I'm just saying that they, in the process, are potentially undermining the task force. Not actually, but...
It's not undermining the task force at all. The task force just feels that this has happened so many times that because of the resistance to comply with our determination and our interpretation of the law, that over many, many, many years, through many different members of this task force, that whether that rises to a willful state that would cause them to find official misconduct. That's all.
Right. I was just trying to acknowledge that these other issues could end up entering the conversation in ethics that we don't.
It could, and went lots of time, and we actually should be present during those to answer those questions and to remind the Ethics Commission, since they are also a lot of new members and don't deal with this that often, of what their rules are around this issue. Let me, just out of expediency, because we have some other cases and it's 7 o'clock, can we take each item separately? Can we know, I think from hearing everybody that there's possibly some agreement on at least the 6716 item, and we can take the 6734 item separately since there's been a lot more discussion around that? Or it's your whatever your pleasure is. You want to combine them, that's fine.
I mean, I'd like to go ahead and make a motion for both 6716 and 34.
Yeah. I'll second that.
And then if that fails, we can take the other action.
Very good. Okay, public comment on this item. Seeing no public comment, call the roll.
On the motion, Member Fisher.
16 and 34.
Sure, aye.
Fisher, aye. Member Hinsey.
Aye.
Hinsey, aye. Vice Chair Hyland.
Pass.
Member Eldon. Eldon, aye. Member Josh Wolf.
Aye.
Wolf, aye. Tesfa, absent. Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Call the next item.
Just to clarify, I assume that we will be drafting a letter to refer this matter to the Ethics Commission. I will work with the chair on that matter.
Very good.
Thank you.
There are some previous letters that we can.
Yes, I will get some together and do work on it. Next on the agenda. Item number 9, file number 17049, complaint filed by Jason Grant Garza against Director Barbara Garcia, Philip Katzenberger, and Basil Price, Department of Public Health, for allegedly violating Administrative Code, Section 67.25 and 67.34, by failing to respond to immediate disclosure requests in a timely and/or complete manner. On June 20th, 2017, the Education Outreach and Training Committee determined that the task force has jurisdiction and referred the matter to task force with a recommendation to find a violation. I'd like to let the task force know that the planning department has provided copies of the video recording that were requested recently.
Public health or planning?
Public health, sorry.
Okay. Thank you.
Before I start?
No,
is it
wait a
possi-
minute.
sorry.
We have a process before that. Chair EOTC, do you want to make a presentation, or one of your members give us a summary of this case?
Do
we know what we're focusing on?
Have either of my fellow EOTC members had a chance to? I didn't review this stuff before coming to the meeting, so do either of you feel? I do remember this case fairly well, but if someone else feels more.
Is that okay? I mean,
what?
Our issue when we went through this, and the issue I think we have now, is whether or not the complainant has gotten everything the petitioner complainant has gotten everything he asked for. There was like a video missing. I mean, that's the only issue.
And I guess Victor had said that he has the video, so
Okay.
it may all be essentially.
All right, well, let's find out. But I just wanted for you guys to provide us with the focus of what the complaint is about, so that we're not going off on tangents. Okay, so this is about receiving weather information. It says 6725, so it was a IDR, whether it was responded to.
It was an IDR.
It says timely or complete manner. Oh, DC Acola.
On page 308, my background summary of the case is like 2 small paragraphs long, if anyone wanted to read it just to refresh.
Okay.
Very humbly offered.
Could we read it into the record, please?
No.
It's
already part of the record.
I just wanted it for part of my video.
No, it's not over here.
One of the things that is significant in this case is because we're dealing with medical records, there's both what the complainant has access to as the individual involved in the medical interaction, and then the public records, and they're not necessarily at all the same. And so as we were parsing this case, some of the things that have been made available to him are only made available to him because he is the patient, and other things are related to privacy, our public records. Additionally, when it comes to the video footage, there was conversations around what technical capabilities the agency has in actually editing the video to deal with anything that needs to be removed for HIPAA privacy concerns.
Okay.
And through the chair, did you find jurisdiction?
We did find jurisdiction.
Yes. It's in the agenda. It's noted in the agenda. Okay, are we ready? All right, Mr. Garza, 5 minutes.
Okay, before you start, I would like to play a video. So how do we do that? Because I want it on
It's
the
going to be
record.
part of your testimony.
That's correct. So how do I get to YouTube so that we
okay.
can play it before we start?
Can you?
You will need to bring it up on the laptop.
Can you please come show me? I don't want to do it.
It is a laptop. You can bring up your website and get it ready to play, please.
We'll just go to YouTube then, please. Now, will that override the screen that I have here that I'm showing?
It will display on the video monitors before each member and on the...
The reason I'm asking is because, I also have paperwork that disproves what's...
You'll need to be able to switch back and forth.
Or maybe just show the paperwork after the video. If I have 5 minutes in a rebuttal, I guess I can show it all.
It's 3 minutes for rebuttal.
That 3 minutes is enough for the paperwork, trust me. I have it all. Okay. Go to Jason Garza.
Sorry, I should have done this earlier.
Well, I...
No,
Oh, I'm sorry.
All right.
No, that's not the one I meant the first.
Not this one? No.
I'm sorry. Okay, the very top thing.
This one?
Yes. Then all my videos will come up. All right. Now, the one I want is, I'm sorry, I'm an old man, I need my glasses. Can you pan over here on the top? The one I want is only 50 minutes.
Sit on that row. Let's get back.
Let me just find it for you guys, I'm sorry, because all the rest are 5 and 7 minutes. I want to show you a shorter one. All right, let me sign in, because then that way I
Well,
can
here's
get to mine.
this one's 3.
Is that it?
Yeah, I think so. 3 minutes, 29 seconds.
That's the one.
Okay. Here we go.
Okay, here is the video of the crimes committed at Zuckerberg Hospital. Who are these perps? Hospital staff? Is this the hospital administrator? Is this the security and sheriff staff at the world-famous Zuckerberg San Francisco General Hospital? Denying services to a person seeking emergency services with a letter in his hand from a doctor instructing emergency admittance. How many players are here? How many are involved? She's taking the letter. She's reading the letter. She's telling me I cannot videotape. I'm asking, what is the law? Please quote me the law. You're witnessing the assault.
Josh took me down and we were starting the sound wall and I took it down. He stopped out like, I don't know, it was like,
being escorted out by security. No law enforcement officer to protect my ADA or medical rights or civil rights or any rights whatsoever. Operation in full swing. Patient dumping, Impala violation, getting our story straight. Officer walks back in with my camera, my phone, hands it off, right here, hands it off. Who is this person? Is this not more criminal activity? Invasion of privacy? What about theft? Please remember, I was videotaping. I do not have the videos. They deleted my videos. It's known as destruction of evidence. Look at all the complicit players. Does security not know that something is illegal happening with my phone? Are they not law enforcement officers? Or is the $12 million MOU through the Department of Public Health all they need to cover their ass and screw people out of their rights? Yes. Here's the second part of the operation. We'll give him back his phone and his letter from the doctor instructing him to leave. Operation success. Patient dumping 101. Now, all we have to do is get everybody to say that he was never here, there was never a record, so if it's ever investigated, there isn't one. Oh, that's right, it was investigated by the California Department of Public Health, whom I informed I had a video, everything else, who never contacted me because that is their rig procedure. Oh, it just goes on and on and on. So, how do I switch this back to? Is that the one? This thing here, the overhead.
You just had it. There you go.
Okay, this is the doctor's note. 411. Admit me for emergency.
In the microphone, please. Thank you.
Admit me for emergency. This is the letter from licensing and certification stating that they went to go check my complaint, that there was no records of me being there. This is the records from Karen O'Donnell when I sunshined them. There's no records of me being there. My, they're getting their story straight, aren't they? This is from Miss Acosta when I sunshined them for my records in the video. We can't release this because there's a HIPAA violation. Did you see any other patients there? Did you see me recording any other patients? Or was that HIPAA violation, which, by the way, Mr. Wolf was supposed to have a hearing on so that we could determine what was meant by HIPAA and HIPAA violations years ago and didn't happen. Sorry, I should be recording this on my camera. Another failure. Okay, let's continue. Here is where Miss Acosta writes back and says, well, here's your videos. Can we not go in front of the Sunshine Commission now that you've got your videos? So that I don't have to be accountable for all the lies that I said in the training that you know, it was a HIPAA violation. Oh, I'm sorry. We can continue during the rebuttal. I've got all the paperwork for the Ministry of Sunshine.
Thank you. Are there any persons or witnesses providing additional facts or evidence on behalf of the petitioner?
Hi. My name is Diane Carpio. I actually have reviewed a lot of this, and it raises serious concerns with how Department of Public Health operates. And this whole interaction, there was discussion about whether or not they adhered to everything that was requested. They did not. They said that in one of the paperwork that there was nothing there no paperwork because he wasn't seen. But he was trying to be seen, but they assaulted him prior to being able to be seen. So the fact that the Impala log, which is federally required, was not provided for that day, despite whether or not his name was on it or not. He wanted everything from that day, from the time that he was there, and they just said, oh, you can't have any of it, because they said the video had other patient identification on it, and they couldn't release it. This is it's a blatant system that's designed to fail and COA. There's willful misconduct in the release of that video, willfully saying there was other patient information on it. It's a public area, so if this body has the power to refer this matter to elsewhere to help correct these issues, it'd be great to find any myriad of Barbara Garcia, who is on this complaint, Bryce, and Karen O'Donnell, who said she couldn't release the video, and then a month later, deny TikTok. His ability to file a claim is on the clock. And normally, I was so grateful for Josh Wolf understanding the importance of video in public area. They're videotaping visitors. They're videotaping patients. Do they have our consent? It's a public area in a publicly funded entity. This needs to be hammered out so that employees working in that area understand that they will be videotaped. People who are public, paid by taxpayer dollars, are subject to that. Thank you. Sorry.
Any other persons or witnesses providing any additional facts or evidence on behalf of the petitioner? Seeing none, respondent? No. No.
Department of Public Health.
Yeah.
Chairman and members, my name is Brent Andrew. I'm the Chief Communications Officer for San Francisco General Hospital. And I'm here to represent the Department of Public Health in this matter. A few things that we want to stipulate. First is that the request was completely fulfilled. Second, with the exception of this videotape and a second one, the request was fulfilled within the time allotted. The fact that the videotape was delivered late is something that we don't contend at all. I'm sorry, this is... Thanks. Thank you. Okay. Yeah, thanks. So we know that the process to fulfill the video request took too long. We didn't have the capacity within our organization to do the editing that was necessary before it was released publicly. We are redesigning our process. We've already dedicated a full-time employee to responding to video requests as a result of this complaint. So no willful intent to keep materials away from the complainant. We had other obligations to fulfill in terms of HIPAA, editing out and excising the presence of other patients before we could release the videotape. You should know also that as soon as hospital administration was made aware of this situation, which we weren't initially, we self-reported to the California Department of Public Health and to the Joint Commission, which accredits our hospital, so that they could conduct their independent investigations, which we're cooperating with fully, in addition to conducting our own. Thank you.
Thank you. Are there any persons or witnesses on behalf of the respondent to provide any additional facts or evidence? Seeing none, members.
Could the representative
Member
from
Josh Wolf. Mr. Andrew. Is it Andrew or Andrews? Andrew.
Thank you, Mr. Andrew.
Sure.
Just so I understand, you explained that when you were made aware of the situation, you reached out to some supervising agencies to investigate. Are we talking about the public records request or what transpired with Mr. Garza?
What transpired on the video.
Okay.
Not with the public records request.
Well, I was a little confused how that
No,
would
right. I
become-
understand.
Great.
And, we're not here to discuss or defend what happened on the videotape.
Right, that's not within the purview of this meeting.
Correct.
I am also curious, so you were able to figure out the editing process to make the video
Yes.
comply with HIPAA standards. What was edited out, and what was the process of the edit? Did you fuzz video out, cut sound, actually snip the tape, so to speak? Not literally, obviously. What was edited?
So you can't see it from this video. You can see it from the one from a different angle, that there's a moment where you can see a cut. That was a moment when a second patient came up to the desk seeking care.
So the way that it was edited was you excised the period of the tape that had identifiable HIPAA violation issues.
Correct.
On it.
Yeah.
So perhaps in this particular case, that's fine. But what would you have done in the event that Mr. Garza's interaction had continued during that period that other patient had entered there? How would you have edited the footage to not raise a question of what happened in that missing segment while also protecting the privacy of the patient?
Yeah, it's a reasonable question. I mean, I think we would have had to come up with a different solution, and perhaps pixelating the face, pixelating the clothing of the other patient to completely eliminate the possibility of identifying them.
Great. And do you know whether you have that technical capability either with you're bringing in a new employee who's dealing with video requests? Is pixelating coverage or pixelating film in order to protect anonymity within the scope of your talent base right now?
So we don't have the ability to do that right now. we're hoping that we get the ability to do that, because it would have been a much faster turnaround for us to do that than it would be to find the particular section and excise it.
Great. Thanks so much.
Yes.
Any other questions? Okay, seeing none, should we move to rebuttals? Okay, so respondent, Mr. Andrew, you go first on rebuttal. If you have any rebuttal. Okay, very good. Declines. Mr. Garza, you have 3 minutes on rebuttal.
Yes. Well, first of all, everything he told you was not true. If you look at the other video, which he's referring to, there was a person who walked by who was not a patient, who was leaving. It was probably just a visitor or something that was cut out. And if you look at that video, there's obviously a patient sitting in the waiting room that they didn't blur out. The other video. I can show it to you if you would like.
Focus on
Okay. In the meantime, there's lies right here. In the representation about the HIPAA thing being the problem here when there is no other patients. They're throwing out HIPAA once again as a canard, knowing fully well. And in addition, her Hobbesian's choice. I could not get this. This is closed. This is the end. It wasn't until I brought her here that this, film blurring was going to be allowable. What a bunch of bull.
Okay.
And then the next one is the records from Karen O'Donnell saying that there's no Impala log. I've requested the Impala log, I've requested the triage log, and the medical screening, which must be there by law. Once you step within 250 feet of the hospital emergency room, in emergency, especially with a letter from a doctor requesting emergency admittance, they must, by law, triage you and provide a medical screening. By law. Now, those are the things I requested. Here is the facts that they did not provide them because they stated that there was no record. You've seen the video where I was in triage, denied the ability, assaulted. Why wasn't the security there for me? Why was I assaulted by this person and security didn't do a thing? And the final topper, licensing and certification after I did the correct thing and tell them, here's what's happened. I've got the video. I'm prepared to come here, tell the truth and everything else, and then they write me back and say, there's no record of you. It didn't happen. Your complaint is unsubstantiated.
Can I get in here for the last minute? Finally and foremost, there's supposed to be a representative from DPH who can attest to the records provision of this. They sent this man who was not party to that, not on this letter, not a part of, so it's hearsay. So the DPH did not appear. Mr. Bryce did not appear for records that were requested of him. Barbara Garcia did not appear for records that were requested of her. And Karen O'Donnell did not appear to talk about why she initially said that she could not release this video to him, which is willful misconduct and lie. All of a sudden it comes out, it's delay, deny. You can finish up, sorry.
Yes, I just have one really quick thing to say. The biggest problem with all of this, sir, is that I've been coming to you guys for years about getting this policies changed and everything. So now, since they haven't changed the policy, if I show up tomorrow in emergency, are they just going to do the same thing all over again? And not see me, get their story straight, lie to licensing and certification, because they have your blessing here. I requested this paperwork. Oh, well, we didn't make it. It doesn't exist. Excuse me. It has to exist by law. I've just shown you where I was there, where that generated the fact that it has to exist. Impala law. Would you like for me to explain it to you? Because I can. In addition with HIPAA, which of course, I'm still waiting for Mr. Wolf's hearing on HIPAA, so that I can show you that all these things that the Department of Public Health keeps throwing out for HIPAA is
please
bull.
wrap it up.
Thank you.
Okay, members? All right, I have a couple of questions. Mr. Garza, I have a question for you. So I'm trying to find your original request to the to DPH.
It's right here.
Can you tell?
Fortunately, I keep everything.
Okay.
There's my
so
immediate disclosure request.
Okay, hold on. I want to try and find it in our, so I can get all the other.
304, 305?
304, okay. Oh, okay, you got it up there. Okay, great. Thank you. Okay, thanks. Just give me a moment. No, I'm looking for the request.
It's
to
on the
DPH.
bottom of 304 where it's addressed to.
Oh, okay, got it. Immediate disclosure, I got it, okay. Okay, thank you, Mr. Garza. I'm going to ask Mr. Andrew a couple of questions. So, Mr. Andrew, I'm looking. There are three items here in his request to the hospital. The first one is regarding the video on 411. The second one is a triage report and medical screening report as required by EMTALA. And the third one was a request including all paperwork regarding this incident. So you testified that you provided all the documentation?
Yes.
Okay. So you've provided the triage report?
Well, I don't think this particular patient was triaged.
Okay. And the medical screening report?
I don't think the patient had a medical screening.
You say you don't think?
Yes.
Is that the official position of the hospital?
Yes.
Okay. And what about this Apollo report?
The Apollo report?
Yeah.
I'm not familiar with that.
Okay. I thought that maybe I misunderstood.
EMTALA.
Okay.
EMTALA.
Got it.
Which is Emergency Medical Treatment and Labor Act.
It was the only thing Reagan did of any use for that whole 8-year term he served.
Thank you. All right. Okay. So,
and I mean, Mr. Chairman, we'll be discussing EMTALA violations with our licensing agency.
Okay. All right. Great. Thank you very much.
Thank you.
Okay. Mr. Garza, where did you, the video that you showed us, how did you come across that?
Oh, I'd love to tell you, sir. I sunshined it. And I showed you the letter where Ms. Acosta wrote back and said I couldn't get it because of a HIPAA violation, and that was her Hobbesian's choice. I also sent you paperwork in where I constantly tried to follow up with her and say, well, I need to follow up with this. I don't believe it's correct. I still need these things. You're supposed to assist the complainant in receiving things. Nothing.
And what do you, so they've confirmed and admitted that fault regarding the lateness of the delivery of the video. Is there any other documents that you did not
I don't have the Impala log, which is required by law. I don't have the triage log, which is required by law. I don't have the medical screening log examination, which is required by law. So this is the third time I've told you. I don't understand the question. Please ask me the question again. I have not received what I requested, which must be there by law.
So I'm asking with regards to the triage report and the medical screening report as required by EMTALA, you're looking for the information that involves yourself in these?
What I'm looking for is for them to be able to not break the law, not fill out the reports like they're supposed to, and then come to you and say, well, there's no record. So you can wash your hands of it, and we can too, because it was set to fail because we deliberately took all the steps to make it fail.
Mr. Garza, I'm really trying to help here, okay? Sure. Go ahead.
Essentially, he received a letter from Zuckerberg saying that the custodian keeper of records revealed no medical records or no EMTALA log on Jason Garza for that day. He requested this log for that day which should have been redacted. All names should have been redacted, but they should have provided it.
Okay, so he did not receive it at all. Mr.
No.
Andrew, can you please answer that question? So we got the first part around the video. Let's go to the second part.
Okay.
Now, I understand you're saying that because he may not be included in it,
Yes.
that you didn't provide it.
Correct.
It's a public record. The requester made a
Patient
request on
record.
it. You have the responsibility to withhold certain information through process of redaction or other provisions provided to you, if there are any. Why wasn't this the report provided to him?
So it could be that the person fulfilling the request interpreted that the patient was asking for his own record for that day, of which there was not.
Okay.
So if the question is, why didn't we send the entire log for the entire day, it was likely that the person fulfilling the request did not interpret the request in that way.
Okay. Can this be done?
Yes.
Okay. Can we make that happen?
Yes.
Okay. I appreciate that. Okay. And so, Mr. Garza, is there any other documentation? Because in number 3, you state all, paperwork sent and what have you. I mean, it's not very specific. So I can only, we can only go by with whatever documentation they say they have or don't have.
Presumably, there would have been a record of the security and escorting him out. The other employee that was hit when the one DPH employee flung Mr. Garza around to the other side. You can clearly see a second woman who worked at DPH being hit by Mr. Garza after he hit the wall and flying. So there's got to be an incident report somewhere on this horrific circumstance.
Okay.
That has not been even addressed anywhere because basically the representation is that he wasn't there. There are no medical records. There's no EMTALA log. I can't release the video.
Hold on. I want to get the specific list you got going here. Okay.
Thank you. Sorry.
Because if you do that, then we may or may not get agreements for certain things.
Right.
Okay. Because to put number 3 it says request includes all paperwork ongoing regarding the incident.
Not ongoing from that day. I mean,
It says here the request also includes any internal documentation generated by the incident concerning this matter.
Okay.
And all agencies involved in this particular incident.
Right.
So you get
Yes. Thank you.
The thing is you seem to know what you're talking about. If you're going to ask for specific documents, while we have a person who can actually make the decision.
Right.
The decision maker here to release certain things, or at least can go and talk to people who can make the authority for those.
One point I would like to make is that he responded to your question about why the custodian didn't release the EMTALA log.
Right.
And he answered for her, which he doesn't know. So her failure to show up to answer that question.
I get that point. It's a different issue.
All
Okay.
right.
I
Sorry,
understand
thank you.
that point. Okay. And that's it, Mr. Garza. That's all the information I need. DCA Cola?
I just want to clarify. So the complainant is now alleging that he wanted, a triage medical screening, a triage report and a medical screening report, not for his own information, but for anyone else that came in that day?
He was requesting the log so he can see if he showed up on the log or not. And as his friend said, they could just redact the entire thing except for what pertains to Mr. Garza. Why is that? Is that an issue for you? It seems appropriate to me. If looking at this video, if there's no record of me being there, and there's supposed to be a log that somebody's or an incident report or something Seems a little...
There's sensitive medical information in that. I suppose you could redact the whole thing, but if you acknowledge that there's no record, that he's not included in there.
But he didn't ask for it about himself. He asked for the entire log. The entire log, if it's a public document, it should be produced.
Well, I think you need to
or redact it or withhold it because some law tells you can withhold it and not produce it.
So maybe there's a failure to state a reason for withholding there, but I don't think you could disclose a document that's medical patient information. I don't think that's not subject to public records laws.
Right. It's why, but this is a log. So the question is whether this EMTALA is patient record or not. That's another factor with regards to this. Mr. Andrew, you want to
Does HIPAA apply to an EMTALA log?
Yes. So you asked me if we could produce the log but redact all identifying information.
You said yes.
Yes,
Okay.
we can do that.
Fine.
Yes.
Okay.
Wait, there's the problem, though, through the chair.
What's that?
If you're requesting the EMTALA log through the public records process, I think they'd still need to redact Jason Garza's name from it as well because it's becoming a public record.
No, because
Mr. Garza's requesting it.
We've been through this before with the HIPAA stuff. Is that if a person is requesting their own records,
it's available, but it's not through the public records process at that point. So it's a different process that you're requesting.
That's right. But because this is a government hospital, the information that's in the hospital is also public information. And so this is like
Except for
police
patient
department investigation records and all that. It's the same difference. There are other laws that apply that will provide for redactions or withholding or what have you, but it doesn't take away that the information is public or not. And it's the fact of the matter is whether it's public under state law.
Right. I'm just saying that if he makes the request for the document, we already know his name's not on it because he's testified to the fact. So he doesn't
know. He hasn't seen it.
Well, he has testified to the fact that his name's not on it, actually.
He was never entered into the system.
Okay. But that doesn't exclude the ability of the requester to see for themselves.
It doesn't exclude that. However, what he's going to receive is a list of blacked out lines. So I don't know how he would be able to verify that his name wasn't one of the blacked out lines. And because the Public Records Act portion of it is separate from the HIPAA thing.
But under HIPAA, he can request in a public document his record. So that record would not be redacted.
Except I don't think you can request.
Yes, you can. Absolutely.
Can I finish my sentence?
Sorry.
I don't think you can request the EMTALA log under HIPAA. You can only request that under our public records law.
No, the question is if it's part of his personal record.
Okay.
And if the EMTALA log has been made part of his record because of this incident, that would be grounds for release of the information.
Through your chair.
Yes, DC Acola.
He could get his own records pursuant to HIPAA law, but anything provided through a Sunshine request then makes that information a public record for anyone else that subsequently requests it.
Right.
So through the public records request, they'd have to redact his name.
That's it. That's for them to decide how they want to apply HIPAA with regards to the public disclosure.
Okay.
That's for us. It has been found by this body many times that the records of city agencies and departments are public records, and once they're declared public, there may be other laws that prevent the release of certain information that's in it, like we've experienced with the police code, with the penal code. But it does then mean, you're right, it does then mean it makes the information still public anyway. And so, either by subpoena or whatever, those things could be demanded also through that means too. So That's the thrust of what this is. If we're talking about a private hospital, like private convalescent hospital, or something like that, that is not a public entity, it's a completely different story because they're not under the CPRA. Now, if the CPRA was very specific that said hospital records, all of it is exempt, that'd be a different story. Then it doesn't belong here.
Through the chair, quick question for Mr. Andrew. I just want to confirm that the triage report is a report of all people triaged that day. In other words, a log, and the medical screening report is a log of all people screened that day.
Yes, sir.
Okay. Point of order. Point of order. This question is Mr. Andrew. Okay, so he's asking for the logs. This is not an individual document pertaining to an individual
Correct.
person.
You're asking about the logs.
Yeah,
Yes.
this is a collective document he's asking for.
Correct.
Or a log, or
Yes.
an index, if you like.
Yes.
Okay, thank you. Through the chair, my position on this is that I think the respondents have been responsive. They've gone to the lengths of editing video. They've tried to answer everything here. I think with, the representative's word that he'll provide these documents suitably redacted is good enough for me in this case.
Okay. Anybody else? Sorry.
So I have a motion to find no violation in this case.
They've already admitted to having been late with the video. There is a violation. With
all right, I retract.
I think we have
that motion then.
I think we have two violations here. We have the fact that it was an immediate disclosure request, and the response to say, "Here's what we're doing," didn't come within the immediate disclosure request timeline. I think it's the 12th to the 18th. So we have a failure to deal with that, and then the videos themselves extended beyond the timeline for a public records request. So we have two time violations.
Do you want to make that motion?
I don't have the numbers handy, but yes.
So it was 6725 is for the IDR.
And yeah.
And the other one was for, it's all part of the 6725 because the request was made under only the IDR.
Yeah, so we'll just go 6725 then.
Okay. There's a motion to find a violation of 6725. Is there a second? 6725.
Second.
Moved by Member Josh Wolf, second by Member Hensy. Public comment.
Members of the task force, Ray Hartz, Director, San Francisco Open Government. Just to give you a little background, from 1996 to 1999, I worked for AIG, the American International Group, teaching insurance to people who sold insurance. And I held a broker's license and whatever, and this whole thing stinks to high heaven. Number one, Mr. Garza obviously was at the hospital. And yet we have a letter here from the CPH saying, well, basically, there's no record of you being there. Mr. Garza argues that I should have been triaged, I should have been, seen, and he, as far as I understand the law, yes, if you show up in the emergency room and you say I have a medical condition, now he had a letter from a doctor, for heaven's sakes, they should have at least entered him in the log. And as an insurance person, I would have said to the hospital, you mean you have people who come in who have a doctor's letter recommending them for triage, you don't even enter them on the log? You kick them out? And so basically, you put yourself in a position where, okay, can you prove that he didn't deserve or didn't need to be triaged or didn't need to be seen? He had a doctor's note saying he should have been seen. You can't even establish that he was there, yet you claim that he wasn't there. And when the licensing bureau comes and says, let's see the records, you say there are no records because he wasn't there. But we know he was there because we see the video. So it's kind of like you're the hospital. Now, when they're talking about additional documents, if I'm the security staff and we forcibly eject somebody from the hospital, I'm going to fill out a report to cover my bet. Because if there's a complaint filed, which apparently there was, I need to have some documentation that there was a justification for A, not seeing the patient, B, not triaging the patient, and C, ejecting the patient. They have none of that. Now, I have the hard time believing that. Any good insurance person would say to the hospital, if someone walks in the door, put their name on the log, whether you see them or not. You can always go back later and say, not seen. But the fact was he was there and they didn't enter him in the log. So he should be able to at least see the log to verify they didn't even do that. Okay? And so basically what I'm saying is you've got a lot of stuff here that just doesn't sync with what I know of most hospitals and insurance. If they're so worried about HIPAA, they're also worried about liability laws. A patient comes into the emergency room, asked to be seen, has a letter from a doctor referring them for that purpose, and they are not seen, they are ejected. And we're not even going to keep a record of that. I believe they kept records, and their insurance person told them, don't let anybody see those records.
Any other public comment? Seeing none, let's move to a vote.
This is the motion to find a violation of 67.25 for not responding to immediate disclosure requests in a timely manner. On that motion, Member Hinsey.
Aye.
Hinsey, aye. Vice Chair Hyland, absent. Member Eldon. Aye. Eldon, aye. Member Josh Wolf.
Aye.
Wolf, aye. Copra, absent. Member Tesfa. Tesfa, absent. Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Member Fisher.
Aye.
Fisher, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Thank you. Next item.
Next on the agenda is item number 10, reports from the Sunshine Ordinance Task Force committees.
Okay, so I put this on the agenda just to give committees a little report on items other than the complaints that you're hearing. If you're working on anything, if you have anything to report that we should know about, that, you know, issues that you think might come to rise to the task force for decision, now's your opportunity. So we'll start with the complaints committee. Since Chair Tesfaye is not here, we'll postpone that to the next meeting. Complaints and amendments?
Yeah, the one thing I wanted to comment on was that at our last meeting, we heard the issue of where people giving testimony for either side of the issue were not allowed to do public comment when a motion was made. And there weren't that many people discuss. Mr. Hartz was there, and I think Mr.
Point of order. Can we have silence, please, in the room? Mr.
you
Garza?
please, Mr. Garza?
Mr. Garza?
Can you get outside, please? Thank you.
So the discussion was made, and the crux of the discussion was that when a person was giving testimony on either side of the issue, they were providing facts about the issue. And then when it was public comment on motions, they would be providing comment on the process. So that was the gist of it. We think that this is an issue that should be discussed at a full hearing, at a full board meeting, because to me, there is some validity that there are differences in what's being testified to, or what's, or the comment. So that was the one interesting thing that was brought up.
Okay. Member Hinsey, do you have something you want to say on that?
I was at that meeting. I don't think we came up with any sort of recommendations per se. So we're going to, I think, recommend that we hear this item at a full meeting.
Okay. Anybody else want to speak on that? I actually contacted Dave Snyder, who used to be on this task force, who now is the executive director of the First Amendment Coalition. He said he would be happy to provide some testimony on it. I don't think he was able to make it at the committee.
I believe someone was supposed to call in.
Yeah, he wasn't able to make it that day. So we can bring it up at the next meeting if you'd like, to try and get it out of the way. And how much time do you think we should allot for this?
Maybe
God.
Half an hour?
Yeah,
Parties are going to be there. It will take a...
right. It depends. If we'll be on the agenda, so I would assume there would be a lot of people who would want to make comment on it.
Oh, this item will be on the agenda?
Oh, if
Mr. Chair?
Yes.
Well,
the next meeting of this task force in September, we're hearing the item regarding the Ethics Commission, which is the source of this issue being started.
Oh.
I was thinking that we would put it as a separate agenda item.
So it would be just
It should be separate.
Yeah, no, it should be a separate item, but my concern is whether if we have cases that are challenging this, that we should have the discussion first, so that way the task force can come to a decision or a position on this particular issue, and then you can comfortably have the hearing. Otherwise, yes, it will go on ad infinitum.
Right.
Yeah. Okay. So how would you like to? How should we proceed? Should we reschedule the case and have the hearing? You do it that way. Get back to us on it.
Yeah.
Okay.
Sorry, I got lost here. Are we still talking about the
right. There's a case involving the Ethics Commission where this issue was brought up. The people, right? The people being able to do comment, and so the question out here now is: do we postpone that until we come up with some, with a policy on how we want to handle it?
Right.
All right. So get back to us as to whether. So the question is: should we postpone? Should we move? Should we reschedule any cases regarding this particular issue? That's the first one, and the second one is schedule the discussion as soon as possible.
Right, but even if we postpone cases, there's nothing to stop somebody who's given testimony bringing it up at any.
They could bring it up all they want. It's not on our agenda to adjudicate.
Okay,
that's my point. Only the cases before us are there to adjudicate. Member Joshua.
Having been the one that opened up that Pandora's box, I think that it's important to recognize that it isn't the case itself that's creating this situation, but the people involved in this particular case who could likely go into this issue. So I think that having a discussion over continuing the hearing on how to deal with people both offering facts and evidence and testifying about motions should be done at the earliest chance we have, but I don't think that the actual case pertaining to the ethics is really directly connected to this issue, and so ideally they should be scheduled ahead of each other, but they're not actually part and parcel.
All right, let me just suggest this. Do you want to have the discussion about this before we hear the case on the same day? Does it matter? What do you?
I think that sounds like the best. I think the best solution is to have earlier in this meeting the conversation about whether or not people can talk twice, and then hopefully we resolve it by then and move forward.
We'll make that so. Anything else?
Nope.
Okay.
I did have one thing. I did speak with the committee at the last meeting, and I believe we're in agreement that we're going to change the meeting date to the third Tuesday of the month at 4 o'clock. Or was it 4:30?
I read 4:30. Either one is fine by me.
It's at the discretion of the committee in terms of time, so I will make that change to the third Tuesday at 4:30.
Okay. EOTC, do you have anything to report?
There's not a whole lot to report. We've been trying to deal with making the agenda issue solve itself, where agendas aren't getting posted, and the IT issues. And then the drone policy, which Member Moss had brought forward, but that's all basically old news, so nothing new to report.
One pending issue before EOTC in regards to, I believe you requested a speaker to address how joint meetings should proceed or to develop policy or recommendations on how joint meetings between different bodies should proceed. We were going to bring in a parliamentarian. However, I haven't identified anybody at this point.
Okay.
All right, I'll work with you on that.
Sure.
Okay.
Member Moss? Joel?
Okay. Oh, Member Moss, sorry.
Sorry, on this drone issue, since it's been raised, as both Chair Wolf and I read today in the
Wait a minute,
Examiner.
is this an EOTC committee
This
issue?
was an EOTC.
Okay.
This went from IT to EOTC, and
Okay.
that's where we are. And
Very
then it
good.
came here. So just an update. According to the Examiner, the Fire Commission is set to vote on their drone policy in 2 months. So it wasn't on this month's agenda for us to finish up that letter, but it should certainly be on next month's, I think.
Are we to take a position on this and then
Well, we have
advise the city family on it?
Well, the letter that I drafted before was addressed to the IT and to CC the departments so they are aware of the issue in crafting their own policies. So,
Okay, great. I'll finish that up with you. Okay, that's it? Okay, rules? Ms. NC,
Yes.
is there anything for you?
No, but I have a work conflict for our scheduled rules meeting, so I believe we're going to have to postpone that for another month.
So should we reschedule it?
Yes, we were looking at rescheduling for September, either on the 3rd or 4th Tuesday.
Okay.
We do have a list of items that we are looking at. If anybody else has additional items you would like in regards to procedures or bylaws for the Rules
So
Committee.
it's,
Who's on that committee?
it is Fiona, Ms. Incy, and Ms. Tesfaye, and it was Ms. Baranetsky, who's no longer with us, and I'm filling in for that. All right, so let's work with Member Hensey on a date for
Yes,
September.
and a draft agenda.
Okay, great. IT ad hoc?
So there are a few issues to bring up. One, I believe Chair Wolf is talking about in the next item, which is related to SF Government TV. We did learn quite a bit, but I'll save that till the next item. We had a nice talk with the police department about their government QA system for handling public records requests, which seems to be a system that's being deployed not only elsewhere in the city, but elsewhere around the state and perhaps the country. I don't think we got all sorts of, a lot of great answers from them about how the system works, and they didn't necessarily always seem too certain. I think some of our criticisms of it are probably just going to have to get fleshed out when people start filing complaints over it. We also talked about the police department's body camera policy. I can't necessarily remember all of what we discussed off the top of my head, but I think there were certain things that kind of dovetailed with issues with the drone policy. There was certain things back and forth, but if anybody remembers anything salient about that, there's that. And then I think we're still waiting for the city to settle on solicitations for its citywide kind of case management system and whether we can piggyback off that. And
It's
that's kind of where
actually just the Board of Supervisors.
Oh, just the Board of Supervisors. So, just the Board of Supervisors and whether we can piggyback off that. And in the meantime, I think we've tasked Victor with starting to figure out what kind of data we can pull from our decisions. And Victor provided us, I think, today with, was it today?
Yes, I provided a copy of the data sets that I am currently collecting.
Yeah, so from the orders of determination. So at the very least, we can go into it with, and start collecting kind of metadata on orders of determination, like who was it filed, who filed it, who was it filed against, what was the issue, what was the section, things like that. So that's the IT update.
Okay, I don't have anything good. Thank you else to add to that. Any public comment? There is no public to comment. Let's call the next item.
Item number 11, Sunshine Ordinance Task Force Chair's Report.
Okay, so I sent around July 17th a blurb from the Sunlight Foundation. Now, for those who don't know who the Sunlight Foundation is, they are an organization of folks that with chapters around the country, I don't know how many are actually active anymore, that helps spearhead the effort to normalize public data so that it can be retrieved from city databases, and this is in the form of a specialized type of script called an API, and to try to make it as regular and kind of normal as possible so that no matter where you go in the country, you can write a script and you'll get the same information for whatever script that you write. This is a computer coding thing. So this particular article I found interesting because they're now moving into how to get open data in the hands of residents. Because now there's a level of robustness among a lot of states, at least states first, and then counties. And I thought this was just very interesting because it provides some background, considering, we have a sunshine law, most places don't have a sunshine law, and we have a lot of data, and we're looking to create, more databases that make it public, things publicly, information publicly accessible. So I wanted you to become familiar with this. I would urge you to read it through again. But on top of that, I heard through the grapevine just this week that the city is contracting with PeopleSoft. Remember that company?
Yeah.
It's owned by Oracle. It got, not just owned by Oracle, it got bailed out by Oracle because it failed on many college campuses to complete their contracts. They were in breach of like 5 contracts. So it's a database platform. It's what they call, if they're using it this way, an ERP, an enterprise resource platform or something like that, resources platform. But this is, what I was told was that they're going to be using this platform to consolidate all public data so that they can make it public or have a public-facing side to it. So I don't have any other information about it. I have no idea, and so my thing is for the IT committee to call some folks in, probably would be Coit, folks from Coit, to explain what's happening, because when I first started going to Coit, this was the big thing. They were going to create 2 big data centers, and they were going to create virtual machines, and everybody was going to be in there, and everybody was like having conniptions. They did not want that to happen. So this is now being instituted. We should know how and what it is, and actually we should be probably at the table. So we'll request their presence at the next IT meeting. I think it would be good if we can, maybe I'll write a little letter to DT and to Jay Nath asking what the status is. Hopefully we won't get any resistance, because otherwise it'll demand an IDR from us. So that was the first thing. The second thing is we had a very interesting discussion with, who was it? Michael Ng?
That's Jack Chin.
Jack Chin, right. Jack Chin from, who is he from? Where he was from?
DTIS.
DT? He was from DT.
Or SFGTV / DTIS.
Right. So this was in regards to you see all the cameras in the room here now. And so we wanted to know what the deal was, with what was going on with that. But my concern was, it seemed sometimes when an item was coming up on an agenda that all of a sudden the respondent shows up. Right on time, right smack on time. How is that possible? Now, I thought maybe that little camera that's behind us up here in the corner, or maybe even the microphone system, could be heard live through some system throughout the city, throughout the I don't know by who, by somebody, and that's how they were able to do that. So Mr. Chin had informed us that there's a closed circuit television system of all meeting rooms, whether anything's happening in them or not. That is on 24/7 all the time. And my concern about that I voiced was that, so some people get to watch and other people don't a public meeting. And that is I wanted to bring that question before the task force to have some discussion about. So I wanted to just report that to you. I think we should have some discussion about what that means and whether there is a violation with regards to that, whether it's a violation of just the Sunshine Task Force, Sunshine Ordinance, or whether it's it goes beyond that, goes up to the Brown Act. So, Member Moss.
And if I remember correctly, you actually, because I chaired the committee where we talked about this, you actually also wanted to raise the issue about whether we should try to get those shut off until such time as everyone can get access to it.
That's right. Thanks for reminding me.
I want to make sure that's out there. People know that that's
right.
also
So,
something.
and that's kind of why I put this as discussion and action, because if we wanted to kind of like make a request, kind of an injunctive request that this practice stop until it can be figured out whether this is valid or not.
And
Josh Wolf.
I had actually suggested that in lieu of before we ask them to stop and do this injunctive request, we've been talking about how these cameras would cost something like $30,000 a year to run, but right now if you go to some room, you can tune in to the single channel feed that they told us we can't have.
Right.
So, I suggested that before we tell them to shut it off in the building, to port that out online, if they're willing to send that single camera feed to the public, I'd rather do that than shut it off.
Yeah.
Right.
Actually, you can go to the cafe, the open room in the cafe in the basement.
No, I mean,
and watch it there.
It needs to go beyond the cafe.
Yeah,
I know. Go over sfgovtv.com.
I know. My concern was that it's in everybody's office, but not out in the public commons somewhere for people to see. But it actually is. There are a number of places to do it. So go on. Member Hinsey.
Member Josh Wolf's point is, can we leverage this in such a way that we can get it online?
I would rather it not be selfish, just for us, because there are plenty of other boards and commissions and advisory committees that meet in City Hall that don't have the opportunity to be streamed online. And so I would, because of the nature of our jurisdiction, it's one for all for one kind of thing. I think we should try to move this into a way where it applies for everyone.
Well, I don't think that it's selfish if we say, you're already broadcasting this thing, why can't you send this over SFGovTV? And if we succeed, then all the other groups that are disenfranchised can do the same thing. I don't think it's selfish.
I think if we speak on behalf of all the other groups, it goes a lot farther.
Except that, do we know that all the other groups have asked to be broadcast?
It doesn't matter. The point is if this exists already, whether they know it or not, the point is as you're saying, just turn it on.
Sure, we can frame it that way, of like, this is being broadcast, SFGovTV should add a channel of
if
what's
these
currently
cameras are
broadcast.
live right now, which they are,
right,
and anybody in the building that has closed circuit in their office, they could be watching this.
So can they tune different rooms?
Yes, they can tune different rooms. Absolutely.
On a TV? Or
on a TV. They have
There
different.
are closed-circuit TVs in our offices. We can see any meeting we want within the city.
Supervisor's office.
That's
was,
right.
And he was watching, his staff was watching the Board of Supervisors meeting. But could they then switch over to assessment?
Each channel is a different room.
Yeah, so this happens in Congress too, but those feeds are available to the public. That's why you get to see them on the news from time to time, and C-SPAN.
And there's no
So
technical issue.
no, there's no. They have some technical issue. They did say that they're converting some analog system to digital, because one of the reasons why I also had them show up that was part of the IT committee was how fuzzy, how really low resolution the broadcast is online. You can't even read when they put something on the overhead. You can't even read it, and that's like high definition right there. So he said that's an analog. They have analog issues. If you go into the back room here, you'll see a big rack, and that's part of what that system is all about. So anyway, I'm just wondering if you wanted to take action on this, if you wanted to make a request for them to turn off the closed circuit system until it can be determined whether it's in violation or not, or to maybe make a request of somebody to make a decision about this. I don't know. I'm leaving it wide open. I don't know if DCA Cola has any thoughts about this, but yeah, right. I don't want to touch it. For about almost 20 years, I would say, people have been asking for that, and I've heard it's in the amendments actually. So, so I don't know if is there while we're here today and it's on the agenda and it's noted as action or possible action, if you wanted to do something, we can do that right here, right now.
I'm sorry.
Go ahead.
So I'm just trying to look through the ordinance to see if there's something we can leverage. And so I'm like, right now I'm looking at 6713, wondering if there's something there in which it says no policy body shall conduct any meeting, conference, or other function in any facility that excludes persons on the basis of actual or presumed class identity or characteristics, or which is inaccessible to person with physical disabilities, or a member of the public may not be present without making a payment or purchase. And I know that's generally we're talking about making sure they don't hold meetings in places that are ADA compliant, or they don't hold places where you have to pay to get in. But I'm wondering if the basis of actual or presumed class identity is government employees versus not government employees. And whether we can make that kind of argument that there's a 6713A violation there. I've not finished going through the ordinance looking for other things, but we got to the open up to discussion point.
Okay. Anybody else? Yeah, I was looking at 6714B, but it talks about recording, not streaming, not live streaming, which is not the same as recording, at least in my very technical view.
I mean, do we have the authority to shut down the cameras under 60? I mean, can we? I mean, are we prevented from doing that under 6714A?
No, because the only authority we have is to produce a public record. Well, it
says any person attending a public meeting shall have the right to record, and so theoretically, since there is Victor in the room as an agent of the city, and there are cameras from the city, if we tried to shut down the ability of the city to record, then we
But they're not recording.
Or, well,
that's what's going to come. That's going to be the challenge.
I mean, or to broadcast the proceedings. So it says broadcast, and it is broadcast.
Where does it say broadcast?
Any person attending a public meeting shall have the right to record their proceedings with an audio video recorder or still motion, or to broadcast the proceedings.
But that means like the media.
Or just broadcast.
I mean, it says any person, so.
Yeah, okay. But that's what the general person that would have that equipment to broadcast would generally be the media. But be it as it may, it could be Facebook Live or something like that. YouTube Live or Ustream.tv or whatever, yeah.
So here's a crazy idea, which probably...
6714C, though, it says every city policy body, agency, department shall have audio, video, every notice, regular meeting, special meeting, or hearing open to the public held in a city hall hearing room that is equipped with audio or video recording facilities.
We got audio.
We have video now,
video.
too.
It's audio or video. We got audio.
Yeah, but video depicts, if audio is included with the video, then you get both.
So,
really want to be famous.
so here's
infamous.
I really don't want
infamous.
this. Am I the only one who does?
I don't want to be filmed, but if we do, if we want to push this issue, here's
you already are and have been.
So. In the interest of transparency, I'm going to go along with this.
Jason Garza, YouTube.
You're YouTube famous.
Wave, everybody wave.
Do I want to be? No.
So it seems like by the nature of the video cameras capturing our images, there is some sort of record retention issue of the video not being recorded.
Okay.
So we could, as the Sunshine Task Force, file a records request for the video of our own meeting.
They'll come and say we don't have it, and they'll be in automatic
violation of the records retention policy, and therefore they'd have to start recording it.
Through the chair, we could just go to the police department because the lieutenant's body camera was on the whole time. It had the little red light.
Actually, no, we asked her during the hearing where she testified on the body cameras about whether her body camera was on, and it was not.
The red light was on.
Was it on that time?
Yeah, we noticed it. The red light was on.
That's so. Maybe somebody should request that.
What's that?
All right. Look, we're getting a little slap happy on this. Is there something that you want to do? I mean, we have. Yeah, I created this item with action in case there's something that we want to do with regards to this.
I would like us to write a letter requesting that those channels that are currently being broadcast on closed circuit TV be made available to the public at large via an online
streaming.
An online nexus through the web. That's easier to say. Make it available through the web.
All right. Is there some section of the Sunshine Ordinance or other section of law that you can point to that makes this requirement?
Well, I don't think we need to make. I think we can make the request without invoking law to say that it's necessary. But no, I'm not aware of any thing I can cling to.
I say that because making just a blanket request is like, okay, that's fine. Next, they're not. It's not compelling them to do anything. If you say that you're violating the law under some public records,
we can go back to that they're creating a document momentarily by recording it in video, and by not saving it as a file, it's violating record retention.
I'm just wondering, for the purpose of creating a motion, if we can crystallize exactly the section of the ordinance so that we can make a reference so that they could say, oops, yes, we should be doing this. Or no, we have reason not to because the ordinance says no or doesn't cover
Through the
us.
chair.
Yes.
DCA Kola, what would be the city attorney's response to this?
I don't think that's appropriate. There's an ethical firewall here.
I'm just testing him to see if he's paying attention.
Don't answer that.
Okay, so
his job is to help us. Okay.
Playing devil's advocate.
No.
How would you?
No, please.
How should we best practice?
I would say in reference to any law that we're trying to cite, if he can provide some insight to that as to whether we're on the right track or not, that would be feasible.
I'm asking for his legal mind, exactly.
Yes. 6714 speaks about how the footage can't be destroyed. It's kind of a stretch to say that failing to record it destroys the footage, but I think that there is an argument that you've created this document and you have to save it because the law requires it to be saved just by the nature of capturing it.
That's like walking in front of a mirror and being upset that it disappears.
The problem is that we already have the ability to audio record.
No, it's not about audio recording. It's about the destruction of the video. It actually says that no audio or video recording footage can be destroyed.
Okay.
The footage is being captured. It's going into a TV. As long as it's on, they have an obligation to capture it for posterity. Otherwise, you're destroying it by your system. It's like writing a memo and then ripping it up immediately as you write it.
So you can argue, it probably takes several nanoseconds for this feed to appear somewhere else, and for it to get there, there's a process of recording it, capturing it, and then showing it again through another monitor.
That sounds almost like a Stephen Hawking argument, but yes, I think you're onto something.
I mean, it's like you're showing this body's deliberations in this building, right, on closed circuit TV. So you're producing a representation of what we do. It should be saved. It's.
I think he's off his fence. He has something to say.
DCA Kola.
Through the chair.
Yeah.
I mean, instead of making an abstract argument that there's somehow a sunshine violation for that, why don't you guys make a sunshine request to whoever monitors those things?
There you go.
Get some records about what the actual cost is.
We did.
Oh.
The cost is just under $30,000 for the year for all our current meetings.
We also have a request to Mr. Chin regarding just the second half of that request regarding the closed circuit TV.
Right.
What's currently airing on SF.gov TV?
Probably not not a live committee meeting.
Maybe?
Right.
The police commission?
Yeah.
We got to get our ratings up. That's what I think.
I hear you. Member Moss.
So I just a couple questions. So through the chair to Victor. Victor, did you say you have access to one of these TVs?
Yes.
In your office, or is it just somewhere around?
It's in my office on the shelf.
So I think under 67.14B, this body has the ability to direct Victor to record this thing, this hearing, and then it can't be erased or destroyed.
I do not have that ability. That would have to go through SFG TV.
So
what is the actual television setup like?
Can we just plug a VCR into it?
It's just to monitor.
Can we not point a camera like an actual camera at the screen?
Yeah, but we can set up a camera here.
Wait, we can get Jason Garza to come and point the camera at it.
Let's not.
No,
But just to get back to the point I was going to make, the request you made to the IT department was for all footage, and they came back with that 30K number. Why not ask for a specific 1 hour block and see what they say? Just to see if they have the technical capability of capturing it and sending it to us.
No, they won't. They won't do anything unless they get paid, because they need somebody to sit there and actually push buttons and move the cameras around. They're not going to just have one camera open. They have some protocols on.
Okay, but in their answer of 30K, are they saying we have to purchase 30K's worth of equipment to be able to?
No, it's not 30K of equipment. It's 30K of labor.
Okay.
It's actually having
for however many hundreds of hours a year.
Right. It's for every task force meeting and every one of our standing committees.
So if you do the math, what's that? This certain amount per hour. Yeah. Anyway.
If figure it out. I mean, if we're here, 4 or 5 hours, times 12.
Yeah.
But we could do the request of how much it would cost for SF for the is it the media streaming? The person who was here last time, Mr. Chin?
Chin, yeah.
How much it would cost for Mr. Chin to just send out the single stream that's already being recorded. So he may refuse to answer that, but that's another way is to requisition the cost for the single camera stream, because that basically would require someone to flip a switch and not actually attend the meeting.
Right, but the question, I don't think it matters that much, because somebody would have to be there to actually turn things on or off for every meeting that we're requesting.
But our meetings, Corey, our meetings align with another meeting that SFG's TV is filming, so all they need to do is
Well, there are two channels. There's SFGov 1 and SFGov TV 1 and 2.
But my point is that as long as there's someone on the clock doing some other meeting, they can turn on the switch at the same time.
I understand. Again, this is the contract that they have with Granicus.
This isn't about Granicus, though.
But they're the ones that actually...
They're the ones that do this distribution, but we're talking about...
all part of the same contract.
Through the chair. Sorry to interrupt.
That's how...
It seemed like it was actually two pieces, actually. There's the... And he kept describing how SFG TV does the distribution. We do the distribution, and someone else does the filming. So the current price quote is both the distribution and the filming labor, and most of that's the filming labor.
I'm happy to ask.
Okay,
I'll do that.
And pursuant to that, if we can parse this out a little bit and get an actual number, this can then be the basis of our request from clerk of the board future budgets to set aside X amount of dollars for coverage of maybe just the main task force. Or, at least it'll give us apples and oranges to work with. That's what I'm trying to get to with this, rather than just taking the 30K and they've basically just blocked us with that answer. Because we know they can do it. That much they've admitted.
Okay, so basically you want me to ask if the standard closed-circuit live feed can just be broadcast live.
And how much that would cost. Okay.
By the hour.
No, because we want it on a yearly basis. We want to make sure that if we're going to do this, then you want to do it not just for a short period of time. You want it to be ongoing. So, and then that way it could be fit into somebody's budget. It's probably going to be the clerk's budget. Maybe not. I don't know. Because the task force doesn't have its own, quote-unquote, own budget, so to speak.
So.
Yeah, on the steps of City Hall, right? It's a cliche. Yeah.
Constitution cookies.
All right, so I got the request for that. Do you want to take action on something or not? If not, we'll just let it go and I'll see about this. To me, this is not what I would go after. I would not try to find sorry to say, a half-assed way of making it happen.
Oh, I was totally half-assing it.
Okay, I'm not interested in that. Either they stop closed circuit for everything or just make it everything public online, or they, or something else.
I'd like to get everything public online.
Okay, if you want to make a motion. But it needs to be within the context of the Sunshine Ordinance. It has to be compelling. To ask is just to ask. I can go and make a financial request just for us and find a supervisor to make it happen, if they will. But if you want to make this as if we feel that there's some violation,
I've got a motion, kind of weird, and it just sort of gets the ball rolling. But I think that we should make a motion to have the Sunshine Task Force submit a public records request for the video of our meeting.
Okay.
How is that not half-assed?
Well, it basically is establishing. It's the first step, and then we can decide to just sit there with the sorry, no footage exists, or we can deal with it. But it lays the groundwork. Is there a second?
There's a motion. Okay. All right. So
You said you think you'd like to motion.
No, I said it was a motion. Yeah, it was a full motion.
Okay.
Emotional.
So the motion is to request video recording
from the Kuwait of this meeting.
From the what?
Isn't it? It's
not Kuwait. It's
who maintains the technology of the cameras themselves?
It's Department of Technology with their with the SFGov TV department.
Okay, so to the Department of Technology, a public records request requesting the video from the meeting on August 2nd, the Sunshine Task Force meeting on August 2nd.
Okay.
And if they come up with it, then our jaws are going to really drop.
Yeah. Member Moss.
So just on this theory of that somehow as it is transmitted from the cameras to the TVs, that is both retention and destruction. If that is our position, I just want to point out that that's going to cause problems with the overhead projector and this television here and these televisions here. Because then if it's our position that is
But
retention.
that's all part. Isn't that all part of the closed circuit system too?
Well, I mean, it's its own. I don't know how it works. But
My motion is purely a motion to file a public records request. Whether we want to do something about it will need to be done in a follow-up motion.
Okay. Any other discussion on that before I call public comment? All right, public comment on this item. Now, how did you know that this item was going to be here, to come back in?
I know nothing but nothing. I'd really like to look at one section, which is 6714, video and audio recording, filming, and still photography. Section C. Every city, policy body, agency, or department shall audio or video every noticed regular meeting, special meeting, or hearing open to the public held in a city hall hearing room that is equipped with audio or visual recording facilities, except to the extent that such facilities may not be available for technical or other reasons.
Other reasons.
What's that?
other reasons.
Other reasons.
And it's
Let him
oh,
fin- yeah,
Oh,
sorry,
we're
let's
interrupting
not,
his
let's
public
not
comment.
interrupt him.
Yeah, I just go on longer then. The bottom line is it's the same as with the computer stuff. There's a thing in the law that basically says as you upgrade stuff, you're supposed to take into account the changes in the law. So if the law says I'm supposed to do something, but I couldn't do it before because we didn't have the equipment, and we're buying new equipment, I'm supposed to factor that in. I'm supposed to say there's something under the law we haven't been doing, and now we're buying new equipment. The law requires that when I buy that, I take those things into consideration and add them. It's the same thing. If they're going to put these cameras in the room and they're just going to sit there and only select certain bodies that they're going to record or not record. It's like somebody asked the Library Commission, why aren't these recorded? You're in Corrett Auditorium. You've got the ultimate audio-visual experience here, and you use it for all these presentations and things that go on, and you can't put the Library Commission meeting on SFG TV. Why is that? Because we don't want to. We don't want to see them, and we certainly don't want Ray Hartz and some of these other folks to get up and say the things they say at the meetings and have it broadcast out on SFG TV. The bottom line is they're not going to do it until somebody forces, and I think the motion that's before you right now is appropriate. Ask them if they have something, and if they do, you might be surprised. I mean, what's the worst that could happen? They come back and say, we don't have any recording of it at all. But they might come back and go, well, yeah, we do have a recording. And then all this insurmountable problem that they seem to be having is no longer such an insurmountable problem or quite so expensive. And as Member Highland said, you have to plan ahead for this. If you're going to want them to record this, you're going to have to get an idea and say to the Board of Supervisors, when our budget comes up for next year, we want this amount of money to broadcast these specific meetings. And maybe you start out initially, as Member Eldon said, I think, or Member Moss, I can't remember, just the full task force meetings, or Member Highland, and start there.
Thank you. Any other public comment?
It's the face.
Seeing none?
The glasses. The white.
Any other points on discussion? We don't need to take this by a roll call. Can Member Moss?
I just had one other thought that I do think that this would make a nice joint task force op-ed in the Chronicle or other newspaper about the irony that has been going on about the task force, Sunshine Task Force, not having that. But I'm not prepared to make a motion about an op-ed at this point. So
If it somehow shows up somewhere, it does.
I think I'd actually feel more comfortable if we did do a roll call on this, if
You
that's
do?
okay.
Then there's a roll call has been requested. Please call the roll.
On the motion,
Could we read the motion again?
the motion is for the task force to send a sunshine request for public records related, for a public request for the video of the meeting of the Sunshine Ordinance Task Force from August 2nd from the CCTV system.
Yeah, mazel tov, but sure, let's go for it.
Lou, when you're on TV, you're going to have to know what these motions are going forward.
I like
Please call the roll.
Vice Chair Hyland.
value.
Aye.
Hyland, aye. Member Eldon. Eldon, aye. Member Josh Wolf.
Aye.
Wolf, aye. Copra absent. Tesfa absent. Member Moss.
Aye.
Moss, aye. Member Kanata.
Aye.
Kanata, aye. Member Fisher.
Aye.
Fisher, aye. Member Hinsey.
Aye.
Yeah, Chair Wolf.
Aye.
Wolf, aye. The motion passes. May I ask who wishes to draft this request?
I'll write it.
Member Josh Wolf volunteers to draft a letter.
Op-ed.
And I would like to see it before it goes out. Thank you.
Next on the agenda.
All right, next item. Thank
Item
you.
number 12, Administrative Report, Complaints and Communications. On my report for this month, I have listed the tentative meetings. The Rules Committee for this month will be postponed until September. I have not received anything from the ad hoc committee regarding a new hearing date yet, but I will work with the chair to determine items and date. There was discussion or issues with the complaint committee and the possibility of the need to cancel meetings in November. I believe this December meeting is still okay. However, I believe the complaint committee will need to hopefully reschedule their meeting for November to earlier in the month, maybe the second Monday or the third Tuesday. I will work with the chair.
Please work with Chair Tesfaye on that. Thank you.
Following is a list of new complaints filed for the last month. As you can see, has been an uptick of complaints filed. Last month, we had a pending list of complaints of 27. It has gone up to 36. There are no pending issues before the complaint. There are no pending complaints referred to the committees from the task force at this time. And just a caution that there will be additional complaints scheduled at all committees due to the influx of additional complaints.
Is that it?
Yes.
Any questions for the administrator? Seeing none. Next item.
Public comment.
Oh, public comment on the administrator's report. Seeing no public comment. Next item.
Next on the agenda is item number 13, announcements, comments, questions, and future agenda items by members of the Sunshine Ordinance Task Force.
Anybody? All right, I got a couple of things. This is just clarification, mostly for the chairs. It's not a requirement or the task of any committee hearing complaints to make any recommendations of a violation unless both the parties agree that agree to the violation or that there is no violation. The committee may then recommend to the task force based on this agreement between the parties. I really would urge you not to adjudicate in the committee, even if it's obvious, unless like the respondent says, yes, we have violated and we agree with the complainant, then that's on them to do that. Then you can make that report and that recommendation to the task force comfortably and confidently. But I would urge you not to adjudicate in the committee. It's not the purpose right now. We've tried to redesign the purpose of those hearings is just to make sure everybody understands what the complaint is. Some people are not as articulate as others, or some people understand things differently. Make sure all the documents and documentation is collected, and make sure that you guys understand what it is exactly is happening. So everybody needs to be on the same page. And that's why I asked for the chairs to give a brief summary, because you'll keep the rest of us on point that this is what this case is about. It may not be about all the additional details or rhetoric that people may bring up, but the idea is to keep us focused and on the rest of us focused on a point. Does that seem clear? Can try to do your best on that one. Chairs need to make clear the case particulars and all the documents and evidence are included in the agenda. I was a little disturbed to hear on one of the cases tonight, the member Moss said that there was items that were presented in the committee that were not in today's agenda. Can you elaborate on that?
It's possible. I just couldn't locate them in the agenda. I don't want to say definitively it wasn't in the packet. I just had to go back to my notes where I had highlighted that from the previous committee.
I would really appreciate that you review the agenda. Chairs, basically, review the agenda before your items, the items you've heard, are coming to the task force to make sure everything is there appropriately. I'll also maybe ask, it would be good to have the minutes from the...
I do that in terms of the notes I provide to all the members. I copy out that specific section from the minutes, and I insert it into the notes that I provide to all members.
Okay, that's good. Okay, because please read those notes, because that's your Cliff Notes. I also wanted to respond to Vice Chair Hyland, who had made an inference about, whether the Brown Act or the CPRA, takes precedent over the Sunshine Ordinance and whatnot. And I wanted to read you a section of just the CPRA. that gave rise to the creation of Sunshine Ordinance. It's under the Government Code 6253E. Local agencies may adopt local requirements for, and in E it says, except as otherwise prohibited by law, a state or local agency may adopt requirements for itself that allow for faster, more efficient, or greater access to records than prescribed in the minimum standards set forth in this chapter. Now, this issue came up through a bit of a discussion that our Administrator Victor and DCA Cole and I had with regards to, is it 10 days or is it 14 days? Under CPRA, it's 14 days. Well, it's 10 days with a 14-day, it could be a 14-day extension. But the ordinance doesn't speak about a 14-day extension. It excludes it in order to make things go faster. And that's how the framers desired it to be. So I want you to just contemplate that, because lots of times, does state law trump local law? Well, this particular set of laws is a little different, because the law is giving local agencies the opportunity to provide more expedient, more transparency, creating things that are go beyond what is prescribed as minimum. So I wanted just that to be clear. I don't think we finished our discussion on this per se, but I wanted to mention that because I felt that this is a kind of a subject that does come up from time to time. The last thing I wanted to mention, I won't. It's too much of a hot potato. I'll save it for another time and rethink it. Okay. You don't want to hear about it. All right. Anything else for the good of cause? Yes,
I just wanted to clarify that I was able to find that section in the packet, yes.
Okay, very good. Very good. So, and I trust that our Administrator Victor is doing a good job in making sure it's all happening. But if you do, I think it's important to have your second set of eyes, get familiar with the cases and as you present them in that kind of way. And I understand there are extenuating circumstances, so no problem. There are other members that you can call and ask to, say you take this one, that kind of thing. All right. Last item. Call last item. Huh? Oh, public comment. Any public comment? Seeing none. Call last item.
Item 14, adjournment.
A motion to adjourn?
So moved.
Is there a second?
Second.
It is moved by Member Canada, second by Member Moss. All those in favor?
Aye.
Opposed?